I'll start. 10-yard penalty.
There you go.
All righty.
Morning, everybody. I'd like to call to order this meeting of the Texas State Board of Examiners of Professional Counselors. Today is Friday, May 7th, 2021 at 9:04 a.m. We are meeting via Zoom again because of the continued suspension of applicable provisions of the Texas Open Meetings Act due to continued COVID-19 precautionary safety measures. Hopefully one day soon we will be back in person, but for today we will be meeting over Zoom. I'd like to introduce our, Christina, will you go ahead and introduce the staff and then I will coordinate our members?
Sure. So today we have our board attorneys, Mary Sokola and Rayanne Along, who work on the LPC cases. We have our Bheck General Counsel, Patrick Hyde, our Executive Assistant, Brenda Skiff, Operations Manager, Timothy Spear, and the Bheck Executive Director, Daryl Spinks, and myself, Christina DeLuna.
Thank you. My name is Stephen Hallbearer. I'm the chair. I'm a public member. Dr. Taylor?
Dr. Christopher Taylor, Vice Chair.
Dr. Bradley? Oh, off of Zoom, please. Off of your mute, please.
On mute.
Sorry about that. Loretta Bradley, professional member.
Ms. Janie Stubblefield?
Good morning, Janie Stubblefield, professional member.
Ms. Brenda Compagnone?
Brenda Compagnone, professional member.
Okay. Pastor Roy Smith?
Pastor Roy Smith, public member.
Ms. Vanessa Hall?
Good morning, Vanessa Hall. Glad to be here.
Okay, I will note that at the time being, we have two absences, Mr. Garrett Nairn, public member, and our newest member, Dr. Leah Amuna. If they are able to jump on, we will make a note of it for the record.
I just received an email from Miss Amuna. She is trying to log on, so we should expect her hopefully soon.
Oh, she's in the attendance.
Oh, is she?
On the link. I see her.
Okay, let's see.
She's an attendee.
Got it. I will move her over.
Mr. Chair, we might want to do a motion to excuse Mr. Nairn's absence. That way it's not like an unexcused absence from the meeting. And then if he shows up, he shows up. It's fine. Kind of a no harm, no foul.
Hello, Dr. Amuna.
Hello, hello. I was having an out-of-body experience. I'm like, I can see you. I'm here. I'm here. I'm here.
That's okay. This is your first time, and we're not very harsh. So will you please introduce yourselves? Most of us are meeting you for the first time.
Sure. I am Dr. Leah Amuna. I'm the director of the Student Wellness and Counseling Center for Texas A&M University Central Texas. We're the A&M school without a football team, if that helps. I've been there for about 5 years. I've been a clinician, a mental health clinician for about 12-ish years. I've been a professor for about 17 years. My family is originally from Jamaica, so I do have about 5 or 6 occupations doing things that I love. And I'm just happy to be here.
It is great to have you. We're very excited. I spoke on the day that I spoke with you on the day you were appointed. I learned so much about you, and I know you're going to bring a lot of new perspective and new skills to this committee. We're a team of 9. Everybody brings something unique. Everybody has their own perspective and their skills, and it's just fantastic to have you on board. So welcome. Okay, Daryl, getting back to what you said, we need to make a motion to excuse Mr. Nairn?
Yes, sir.
Okay, since he has not joined yet, do I hear a motion to excuse his absence at this time?
So moved.
Okay.
I'll second.
Ms. Stubblefield made the motion, Dr. Taylor second. All in favor of excusing Mr. Nairn, please signify with raising your hand and saying aye.
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 Thank you. If you'll check your packet, the minutes from our February 12th meeting have been added in. If you could go over those for a minute, and then I will entertain a motion to accept the February 12th meeting minutes.
Hey, Christina, for some reason, my agenda won't go to the second page. So, I mean, I'm happy to be done after this agenda item here, but
I will not accept that.
does anybody else have enough?
You can be done after page 2, but not after page 1.
I'm actually trying to log into another computer to try to pull up the second page myself.
Mr. Chair, I'm happy to make a motion on the minutes if you're good.
Okay, Dr. Taylor's made a motion that we accept the minutes. Do I have a second?
I'll
Second.
Dr. Bradley seconded. All in favor of accepting the meeting minutes from February 12th, 2021, please signify by raising your hand and saying aye.
Aye.
All right. Meeting minutes from February 12th have been accepted. We will go on to item number 4. This is been kind of an ongoing for the past few meetings discussion regarding moving our minutes over to recorded meetings. Just a little bit of background on that. Bheck met on Tuesday, and this same issue was brought up at Bheck. Bheck did vote unanimously to switch over to recorded minutes as opposed to written minutes. Some of the reasoning behind this, and I think that went a long way with the Bheck members. First of all, we now have a Bheck YouTube channel where the recording of the Zoom can be posted. And what we have discovered and what we've been hearing from our members is that it's now very easy to find. It is if you want to find a meeting, if you want to listen to what occurred during the meeting, it's now very easy to find. And that is a big plus for one of the reasons to move over to recorded minutes. Ordinarily, the written minutes are kind of buried in the website, and it is a little bit challenging to locate. So the fact that it's easily accessible to members, to the public, to anybody who wants to see it, that is a big plus. And that went a long way with the Bheck members that voted for this. Any security concerns, those have been addressed. The recording is saved in triplicate. Daryl keeps one copy on a hard drive. It is also stored at 2 other locations, and that's just in case there's an issue with YouTube. We have it stored in 3 different places, just to make sure that it's never lost. Another thing, Daryl is now running these meetings with the closed captioning on, so the hearing impaired can read what is being discussed there. That was another important consideration for Bheck, but Daryl explained how that's working. So we do, that's an accessibility concern that's been addressed. And finally, Psychology Board has already been doing this, and their website is a good example of what it would look like if we choose to do it. It's going well on Psychology. Bheck has now adopted it. So we need to discuss whether we're in favor of it as well. I know it does make a huge difference for staff. It pulls them off of typing up minutes, and they're able to get back on to licensing, to applications, to concerns. And that's important. Anytime that we can make a reasonable change that clears up staff time, it's a great idea to do. So Ms. Stubblefield, I know you have a question there.
My question is there a link on the would there be a link on the LPC website, Bheck website, that takes people to that YouTube channel? Okay. Daryl's
Daryl,
nodding his head.
You want to see what it looks like?
Yeah.
Okay. Stand by.
Daryl, if this takes off, are we going to get royalties?
You know, I don't know if we've got the monetization turned on or not. So
Being a
far,
YouTube
our
star?
viewership hasn't, so far, our viewership really hasn't warranted a check in the mail.
Psychology said they got 2 views in their last meeting. 2 whole views.
So when you go to your individual board page, you'll go to your regular meeting dates and minutes page. And you go here to where it'll say something like this right here. This is how you get to it. And it takes you to where the minutes are stored. Psych board, all the prior to whenever you adopt, if you adopt this way, all your old written minutes will still be on here. But like, for example, here, this was the psych board meeting with YouTube. It jumps up, takes you directly to the YouTube video. So we've got it linked there. And then of course, if somebody actually wants a physical or a copy of the meeting, they just can submit a public information request and we can send them, make a link available to download the actual video or audio file. Or if they need the transcript, we can give them that as well. So.
And board, one of the questions that I had during Bheck on Tuesday was, how would this work if and when we get back to meeting in person? And Daryl explained that we are still going to be recording meetings using what was a wide angle camera that gets everybody in it. And
yes, sir.
So yeah, Zoom is nice because we've got all our beautiful faces here. But when we do get back in person, this can be a new development. We're going to start recording the meetings, and they're still going to be accessible to the general public. Even though we're in person, people can still log on to participate in the meetings. So that was my question about how we would, if we made this change, how would we address it in the future? And there is a plan in place for how it would work. So I realize that this is kind of a change. So let me hear questions, concerns, and if we're okay with it, we'll go ahead and take a vote on it. So let me know what you're wondering about.
I would just,
Dr. Muna?
yeah, I would just add a suggestion out there with regard to disabling comments. Just knowing that things that are out there in the YouTube world, sometimes comments can be very detrimental. And so making sure that we provide access for our meetings to the public without being liable for anything that may be said underneath the video.
We have the comments turned off on all the videos for that very reason.
Awesome. Thank you.
Ms. Hall, do you have a question?
Nope, I don't have a question.
Okay,
I have a question, Stephen.
go ahead, Ms. Campanoni.
Well, I don't know if a question more. I mean, I like it just because of the transparency. I just hope you guys get the right angle on me. You know, I don't want the wrong angle on there because this
You don't
wide
have-
range thing is not good for me.
You don't have any bad angles, Ms.
Oh,
Campanoni.
okay, thank you. Then I'm for it.
Hey, everyone, I'll acknowledge that it kind of took a while for this to sink in. We kind of needed to mull it over and try it over a couple meetings, but yeah, we discussed it a fair amount on Tuesday at Bheck, and everybody kind of settled in that we were comfortable with it. And really the biggest selling point for me is just the accessibility. I like that people can Google LPC board meeting Zoom minutes, and they can find it very easily, and they can go through the meeting and see exactly what was discussed. And frankly, the translation is, we don't have a translation at this point, so it's even more pure because people are seeing exactly what was said and not what was typed up into the minutes. So it eliminates confusion, it eliminates ambiguity. People can go directly to see what we're saying, like right now. So I'll be honest with you, I like the change, but if there's any objection or concern, let me know.
Mr. Hallbauer. Can you hear me?
Yes, Ms. Skiff.
Hey, I know I stated at the council meeting, but I just wanted to reiterate, we do receive comments from the public, Ms. Lamone does, And everybody's been very positive about the YouTube channel. They really do like it.
Good, thank you. I forgot to mention that, yeah, that the comment that we have heard about it when people have asked has been very positive. So, Ms. Stubblefield, you have a question?
I'm ready to make a motion if you're ready to receive one.
I would like to entertain a motion. I'm going to suggest that we make it effective immediately for this meeting today, if that's okay.
Okay.
Daryl, is that
So
acceptable?
moved.
Yes, sir, please.
Okay, so
Okay.
any motion, if any motion, I would ask that we do go ahead and make it effective immediately.
Okay. So I move that we begin recording board meeting minutes through video effective immediately and posted through the discussed channels.
I second.
Okay. Janie, Ms. Stubblefield had the motion, Dr. Omuna had the second. All in favor of moving to recorded minutes, please raise your hand and signify with aye.
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 Aye. Okay, the motion passes. Thank you very much. Daryl, was there anything that you wanted to add? Like we needed to, since we're going to this, do we need to show an affirmative vote for the camera when we do this?
No, either talking or raising your hand is whichever way you prefer. It doesn't really matter.
Okay. Okay. Like Daryl said, if you're on camera, you can stay on mute, just raise your hand. But Ms. Hall, if you're not going to be on camera, I would ask you take off mute and just say aye so we can hear you for the recording.
Okay, this is Vanessa Hall. I agree, or saying aye.
Okay. Then it is unanimous. We will now go to recorded minutes. Thank you, everybody. Let's go ahead and move on to agenda item number 5. This is board review and possible action regarding an application denial. And I believe that Mary is going to speak on this.
Thank you, Chair Hellbauer, members of the board. Ms. Arian is an LPC associate applicant. She was denied based on 3 alcohol-related convictions within the past 10 years, as being directly related to this occupational license under Chapter 53 of the Texas Occupations Code. It was appealed, reviewed on appeal, and again denied. And they are bringing it here. I've been in communication with Ms. Arian's lawyer. I believe they are on this meeting. I don't have the ability to see under the settings that I have for this meeting, but I believe they are here and they would like to present.
Okay, procedurally, I believe that they have 15 minutes to present.
Yes. That's what we've assigned them, yes.
Okay.
Okay, and following that, we are free to ask questions.
Yes.
Okay. So Christina, if you will coordinate this, I believe that's her attorney there.
Yes. Mr. Montez, is your client on the call with you, or is she calling in separate?
Yeah, she's calling in separate.
Okay.
I believe she's in the meeting.
I'm not, oh, there she is. Okay. Hold on just a sec. Okay. So you guys can go ahead and you have 15 minutes combined to go ahead and present whatever you'd like to the board.
Okay,
thank you. Christina, are you going to keep time on this?
Sure.
Okay, thank you.
Uh-huh.
All right, thank you, board. We appreciate the time to ask for reconsideration or listening to the explanations here. We provided Ms. Sokola with various documents. I hope you have them at your disposal. If not, I can just go through them quickly. And I am going to just hand this over to Ms. Arian in a little bit, because I'm sure you want to hear from her regarding the past incidents in her life that have resulted in this bump in the road. Let's say. We've provided documents from Ms. Arian's current psychiatrist's office regarding her non-diagnosis of any kind of addiction. She obviously did have 3 arrests and 3 convictions for DWI. The last one being in 2018 was the last arrest. She is very, very near the end of her probationary period, which I believe ends on June 26th. For the last one, the main point that I'd like to make in all this is we'd like you to consider all the letters of support that she's received. She can tell you a little bit more about where she currently works. I believe she's working as a case manager and office assistant, where she did her practicum, and that's with a private practitioner. Her name is Jessica Belanger. She has written a letter in support of Miss Arian and in support of licensure for Miss Arian. Really, the main point is, she did have the first 2 arrests pretty much consecutively, so to speak, from some issues that she had with relationship back in 2014. Those were combined, and they did result in 2 convictions. The third one happened years later, and she acknowledges that was the turning point in her life. After the third one, she can tell you about the steps that she took to really lead a life of sobriety, which she did not embrace back in 2014. Really complete abstinence of alcohol and continuation of any kind of mental health therapy to root out the issues that caused the behaviors that resulted in those arrests and convictions. Other than those convictions, she's got a clean record. She's obviously educated, and at this point, I believe she would like to get licensed so that she can be employed as a LPCA with Ms. Belanger in her office. And at this point, it's just a matter of conveying to the board that she's on the right track with her sobriety. She attends AA. She leads that life of sobriety that we. I do this for a living, as far as representing and assisting clients with substance abuse issues. I don't believe Miss Arian has a substance abuse diagnosis or issue, but she does have these convictions in her past, and those are the things that she has to deal with as she moves forward with any licensure matter. So at this point, I can turn it over to Miss Arian. If you all if she has anything to say, or if you all have any questions, I'm sure she's more than happy to answer them for you.
I have a question.
Go ahead.
Miss Arian, looking through your documents and your letter, trying to piece together timelines. So I saw the 24, there's 2 in 2014 and then 1 in 2018. Is that accurate?
Correct.
And when did you begin your master's program in counseling and complete your master's program in counseling?
So I began in 2017. I completed in August of 2020. So there wasn't that law wasn't part, or that rule wasn't in place when I began my education for this. And I understand, and I thank you all for hearing this out today. It wasn't my intention to just do this and kind of bulldoze through. But unfortunately, these are the circumstances. So I am doing what I can in order to lead a more just a life that's fulfilling and addressing the struggles that I was dealing with when I received these instead of drinking, of course. So.
Did this last offense occur while you were pursuing your degree?
Yes, ma'am.
And I understand or do you have in terms of, I don't know if you're on probation or what your restriction is.
I'm sorry, could you repeat that question?
Are you on probation or what kind of?
So I am. I had a term of 2 years of probation. I completed everything that was necessary within the first year. And so at this point, I just take monthly UAs that are 6-panel, as well as check in with my probation officer.
And when will that end?
That ends on June 25th.
I don't know if you can hear me still speaking, but we have a letter from her probationary officer in the packet showing full compliance with everything.
Mr. Chair, was this heard by the applications committee already?
Yes, it was.
What was the recommendation of the committee?
Hang on, Dr. Taylor, just one moment. I would like to recognize that we have added Mr. Nairn, and we'll reflect that he is now in attendance. Garrett, good to see you.
Apologize about that. Hello.
Second, yes, Dr. Taylor, this was heard in applications. Does anybody, I know that one of our members has heard this. Do they want to speak on it?
I do. I think one of the things that I asked, I asked a lot of different questions, and I believe that she is on the right track, and I think that she wants to change her life. But looking at the letters of recommendation, for me, I was looking to hear from maybe a therapist, a psychiatrist. Those are the ones that really carry weight for me. Besides those that she's worked with, I really felt that if I had heard from the therapist, the psychiatrist attesting to, example, started counseling, in 2000 something, and is presently in counseling because I'm all about unfinished business. And so if we don't ever resolve the issues that God is there to begin with, then those could be triggered or they could resurface. That's my concern. So today I'm looking at the paperwork, and I'm going to ask again why there isn't a letter of recommendation from a therapist, a psychiatrist, or anyone that you're seeing for counseling.
And I can quickly speak to that, and Ms. Arian can add to it. We understand, Ms. Compagnon, that was that concern about no letter from her LPC. Unfortunately, her LPC became ill. When we realized that you all wanted a letter from her professional counselor, she had been diagnosed with the virus and was hospitalized and was in no condition to write a letter for Ms. Arian. We did provide a letter from her psychiatrist's office, and that's the letter from the nurse practitioner psychiatrist, Ms. Pope. And that's, I think it's Exhibit B in our packet regarding that particular provider and the substance abuse diagnosis that they've indicated that she does not have or does not have a substance abuse disorder.
I'm sorry, go ahead.
But our intention was to provide that letter from Ms. Woolley, Marquita Woolley, what is her licensed professional counselor provider, but she was not able to write a letter for Tristan, unfortunately.
So without getting to that particular document, help me understand the nurse practitioner that wrote that for her. Is she in psych? Does she have experience
Yes.
in psych?
Yes, ma'am. Yeah, I mean, she's the nurse practitioner for the psychiatrist that Miss Arian sees.
So is that more for medication management versus counseling?
No, I believe it's counseling as well. Tristan, would you like to address what happens in the psychiatrist's office versus the LPC that you were seeing?
She's correct. So that is my Dr. Talani is my main practitioner, the psychiatrist. And then I see Lydia Pope whenever she's not available or I'm not medication adjustments. She just checks in to make sure that my life events aren't strenuous and that the medication is working fine, etc. We do a UA twice a month because I am on a Schedule 2. And just to make sure that, you know, I'm not abusing any sort of substance with them. As far as the LPC, I'm not going to pressure my counselor when she's in the hospital. And also, I didn't think it was fair to find a new LPC and then request something, especially when I don't know them very well.
Tristan, I don't think it's about you pressuring your LPC. I think it's about, and I understand illness. I mean, we all have illness. It's really about trying to provide the board documentation that can attest to you receiving counseling, coping skills, and where are we at present time. That's really important to me. I feel like that speaks in volumes. And so do the other letters of recommendation. That too is important because I do see how you work and how you interact and how you're trying to better your life. So I like all of that. I like that you haven't given up, and I don't want you to give up. But for me, I would have liked to have seen a letter recommendation. And you're absolutely right. Getting a letter of recommendation from a new LPC would not have sufficed, just because would not have covered any of those periods.
Ms. Campagnona, and as I'm looking through things, I was going to help you. I think it's about page 9 that has the letter on med management, but I am looking now at page 12 from some of the IOP treatment and things like that. And I'm looking, I mean, it's a couple of months of IOP treatment, which would have been after that third conviction. Definitely, I think that's going to support a part of the treatment process there.
That would be great. So do we have a letter that reflects?
Yeah, it's I'm looking at page 12 of her packet.
Page 12.
From the Right Step San Antonio.
Yeah, I'm trying to, my computer's working like a dinosaur. The backup is a dinosaur.
One of the great things too is Derek Heinleiter, who is my sponsor. He wrote a letter, and in the face of anonymity, he didn't want to put that he is my sponsor on there. But he does talk about my recovery, and he is also a LPCA, or he is an LPCA. So he thankfully knows a lot of what's going on and how these two parts of my life are intertwined.
And we did really try to get something from Miss Woolley, but we just could not ask her to write something as she's in the hospital.
Right.
So it was difficult, an unfortunate situation for Miss Arian, but.
I'd like to jump in and confirm that the very first document in this packet that I submitted to you guys is an email correspondence with Mr. Montez describing the attempt to get the counselor. And so that was documented. This isn't some new information that they're saying today.
Miss Arian, in light of the fact that your counselor is not able to provide ongoing therapy, what is your plan?
So I have an appointment next week starting with a new LPC. And until things either get better with Miss Woolley or if they don't, I'm still going to have something in place because that's going to be important for me moving forward.
Brenda, was that the only reason why why did the applications committee deny the app? Was it just because we didn't feel comfortable without a letter from a professional counselor?
I think it's I mean, again, I want to see her succeed, but definitely I am one that feels that part of recovery is receiving counseling, is taking care of that unfinished business, making sure that, you know, that it's ongoing. And so I didn't see any of that. And so that was concerning for me. At the time of, and I don't recall, Mary, what did I meet with them?
No, ma'am. You reviewed the packet, the
Okay.
appeal packet minus the email correspondence you reviewed.
What was the date on that?
It would be the date of the second, like the day before the second denial letter.
Okay. And the reason why that's going to be very important to me, Dr. Taylor, and her coming back and telling me, Brenda, it was February. I had no idea that her LPC, her therapist, was in the hospital in February, if that was the date, because that would have made a difference because we are now in May. So if she is still in the hospital from February as example to May, you know, absolutely. I'm one to say, you know, let's get this taken care of. Let's see what we can do to support you. But if it's already the month of May, and I'm going to assume that if she was out of the hospital, then there would be an opportunity to submit a letter. But I don't know the dates. I'm just saying that overall for me, it was just, I just felt like if you don't have the counseling, if you don't have the coping skills, then everything else is not going to work unless you can get that back up.
Right. Dr. Bradley, you're also on the committee. Yes. What were your thoughts?
She didn't
No.
participate.
Oh, she wasn't involved.
I wasn't on that committee, but I'm getting ready to ask a question. When did your therapist enter the hospital approximately?
Oh, goodness. So I want to say that was in March.
You're not sure? Have you, so what's happened with you March, April, and May?
So it was, I believe it was at the end of March, our next appointment, because we meet once every month at this point. But our next meeting wasn't until the middle of April, and that's when I believe I was asked about a letter. And so when I contacted them, I couldn't get through. And when I finally did reach someone, it was her husband. And her family said, you know, she's in and out. It's not a great time right now. And I kept in communication with him. And then last week, once again, I reached back out and he said, you know, if I need a letter, that I might want to just like move along to find a different counselor at the time. So
I can speak to those dates. I wrote a letter to Ms. Sokola regarding Tristan informing me about her counselor being in the hospital with the COVID. That was dated April 6th. So I think Ms. Arians only missed April and May as far as LPC appointments that she normally has. So hopefully, you know, that I think she was trying to give her time to see if she could recover, obviously, because, you know, some people do recover. But I think probably at this point, Miss Arian's probably going to move ahead and find another counselor.
And Mary, did you find that date for me of when I reviewed that paperwork?
It would have been, I believe, 4/5, April the 5th. I sent a denial letter April the 6th. I asked you when you expressed wanting to hear from a therapist, I asked if you would consider a Zoom meeting, if I could get the therapist. We then learned immediately thereafter the therapist wasn't available from Mr. Montez, and that's documented. It's the first document in your packet. And here we are.
Okay, thank you.
And just to clarify for the board, she is trying to get an LPC associate. So she will still be under supervision for the minimum 18 months to 5 years. So I
Right.
just want to make sure we're clear on what licensure level she's looking for.
Yeah. I'm just trying to get clarity from the applications and supervisions committee. So who was all on that committee that heard this case?
So we don't do the committees like that anymore, how we used to.
Oh,
It just
who heard
goes
this?
to one person, only Ms.
Oh,
Campagnoni.
okay, okay, that's it. Okay, that makes more sense. All right, thank you. So Brenda, that was the only concern that you had, was just there wasn't the letter from the, okay.
But that makes sense. Her being in the hospital,
Yeah,
that
no, it
makes
makes
sense. I just didn't have that information at the time, so.
I hear that.
Mary, can you explain how the end of the probationary period, which I believe is in July, how does that play into this?
Well, I think the first thing is, you know, immediately I looked at the clerk's records on this to see if there was any motion to revoke probation or any indication that she may not have succeeded in probation. And I mean, even before we had the letter from the probation officer, and she had succeeded in it. And at this point, it would just be an absolute shocker that anything would go off the rails in the last few weeks of a probation. She has completed everything. You can see it from the docket sheet that she's asked to do. So this will be done in a matter of a few weeks for her. When they're on probation, she described doing blood work with her doctor's office. They have to do UAs as a condition of their probation. So you know, very few people are doing more urinalysis and blood work than this woman has done in the last 2 years. I don't think there's any question about that. She will have successfully completed it. I think what's interesting though is not the most recent one, but the earliest one was 2014. And that, you know, she's about to be, in 3 more years, that first conviction will likely not be able to be considered because there is an issue under the rules of evidence in civil proceedings about using convictions that are over 10 years old. So this whole thing is going to age out for purposes of the Texas Occupations Code in applying that analysis under Chapter 53. And I think that that's an important component here.
Okay, thank you. Board, does it make a difference to anybody that the probation period is, that we're still in it? I mean, we're at the end. It's pretty close, and it sounds like she's been very successful during the probationary period. Does that factor into anybody's concerns? Is that, at least as of today, she still is in the probationary period, even though she's close to the finish line and has been, I don't think it's disputed that she's been very successful in probation.
My only concern would be setting a precedent. I always like to err on the side of caution. I like to be as conservative as I can. And if we decide to say, you know, yes, things look like they're going to be on the up and up for this young lady. She's made drastic changes to improving her life. But if someone comes before this board later who may not have all of the things that she has, but is currently on probation and towards the end will we be able to maintain whatever precedent that we set today?
Thank you, Dr. Moon. Good point. Board, we have different options here. The way I see it, we've got three different options. First one, we can deny this application. Option two, we can approve the application and we're done. And option three is we can approve the application with conditions. And I think if we were identifying specific conditions, the fact that she still is on probation, we might want to wait until she has actually completed it. Like Dr. Muna is bringing up, let's not set a precedent here to where we cut short the consideration of the probationary period, or as our professional members have been discussing, the lack of a letter from her therapist. Is there any? So I view it as if we approve, it could be, it's going to be effective following the completion of the probation and with a letter from her therapist. That might have to be a new one though, correct? Right.
Yeah, I mean, given everything that she's gone through to try and get the letter from her original therapist, I understand that it may be a need to get it from a new one, but understanding, kind of like Ms. Brenda's concern, giving her time to establish rapport and relationship with this new therapist, so they're not just checking a block with this letter, that they've had enough time to meet with her, review her history, build a rapport and a relationship prior to that letter being written. So I would suggest putting a session minimum on that letter before it is provided.
I think also in regards to the therapist that she's been seeing, and Ms. Arian, is this a solopreneur? Are they all by themselves?
She is solo.
Yeah, because I was thinking, even if you just did a records request, and you know, we could just kind of say started therapy here, has X number of sessions, that but yeah, if it's a solo person, that's a difficult one.
Okay, professional members, if Miss Arian came to you and explained her situation, at what point, at how long would it take for you to feel comfortable to provide this recommendation? Kind of give me your opinion, some timeline maybe?
I would say 2 to 3 months.
Okay.
Probably say about maybe 6 months to a year, varying on the issues. See, I don't know. I know the issues, but I don't know how deep rooted those issues are. Just again, just,
okay.
you know.
Dr. Muna, what do you think?
I would actually compromise in the middle between both. I would say the number of sessions would be important, and that would play out on the availability of the clinician to see them. So if you're seeing once a month, I would lean towards that year timeline as Dr. Bradley. But if you're able to see once a week or once every other week, then that timeline would be shorter to more in the 3 or 4 month session as opposed to a year.
Okay. What I'm having an issue with here is, are we really punishing her because her therapist was sick?
No, no. It has nothing to do with punishment. It has to do, Stephen, with the fact that as clinicians, we understand there's a process. And the process is that from the time you do your intake and you develop a treatment plan for this individual, that you're covering different areas that may have been traumatic or what early childhood experiences, which now have surfaced into adult issues. There's a lot of things. And so for me, the concern is, have those issues been addressed? And if so, her professional therapist would have been able to tell me that.
And Ms. Campanone, I regret saying punish. I didn't really mean it like that. I'm saying we're penalizing her because she cannot get this letter from a therapist that she already has an established relationship. So she's having to start over, and that time frame is now extended because her therapist was sick. That's kind of more what I meant. And I apologize for the the misspeaking there.
That makes sense. And even again, I'm, I've got professional members on here with great ideas and thoughts, and I want to entertain, what Janie and Dr. Taylor and everybody has to say on this matter too. Loretta, again, I want her to one day join us and become licensed professional counsel. I want that for her, but I also want to be assured that those issues have been taken care of.
Are we talking about a precondition to her even receiving the associate license? Is that what y'all are talking about?
Yeah, Daryl, my understanding is that we cannot issue a license with stipulations, that it's either a full license or it's not a license.
No, we can issue an eligibility order.
You can.
Yeah.
Well, I mean, you're talking about pre-issue of the license, not once it's been issued.
No, we'll issue the license and she would be subject to an eligibility order. We used to do it all the time at psychology. And
okay.
One of the ways we tackle.
Noah felt strongly the opposite way with the dental board, with the dentist that we had that issue with. That we denied his application. He got it through stuff.
I remember that case, Dr. Taylor.
Yeah, so he's licensed now. And it was made clear to us that we couldn't add stipulations like you can't work with female clients or something like that.
No, you can issue. No, who told you that?
Well, that was back at HHSC. So
well, there's your problem.
One of those attorneys.
There's your problem. Stop that thinking right now.
Daryl, tell me a little bit more about the eligibility order.
Okay, the way we used to work situations like this at psych was we would oftentimes issue an eligibility order that says, look, we're going to give you the license, but you're basically going to be on, it's a non-disciplinary form of probation. You're going to have to go to your therapist or your counselor, and that individual, you're going to be ordered to follow any and all recommendations they give you. And you have to follow those recommendations. If you fail to do so, then you're in trouble with us. And then we oftentimes required that therapist just to submit a quarterly report. You can pick the frequency, a quarterly report to our compliance officer, just so that we would know they're showing up, they're making progress, they're doing what I ask them to do. And then at the end of whatever period of time, and I mean, you could make it for the entirety of the associate license if you wanted. I think that's probably a little too far out. But you could say 18, 24 months, you're going to do this. And at the end of that time, as long as there have been no issues and the therapist is like I'm not seeing any problems, they're continuing on. They don't have to be quote unquote cured at the end of that 24 or 18 month period, whatever you choose. But just as long as they're making that progress, give them the license and let's bring them into the fold.
And remind me again, the start date, Tristan, with your therapist was on what month or year? What was that? Remind me again.
So that would have been in December of 2018.
Okay. See, if it had been like January 21, but we're going back 2018. So kudos for that, Tristan. Kudos for that. Just the fact that you've had, those 2 years. And again, I don't know whether that's been monthly or biweekly. So, but again, for that reason, it's so much more important for me to just hear from her. Hey, this is the progress. This is where we're at.
And I would add one thing, oftentimes we would also condition our eligibility order that in the event you don't comply with your therapist, or in the event you obtain yet another conviction, you agree that that's immediate grounds for revocation of your license. No questions asked. You're giving it up. That way we don't have to come back and fight and argue over this. Mm-hmm. So that's kind of that's the sword of Damocles, but you've also got a carrot in front of them that allows them to proceed forward. So.
Yeah, Daryl, I like that. That's an eligibility order with teeth. I can support that. If we can identify, if that, like you said, if that is the sort, man, you come up with the strangest sort of what? And
I'm an educated savage.
There is the, so there is the explicit, it's almost like we have an agreed punishment should there be a violation. Okay. I can support that. Can we identify the conditions that are acceptable for an eligibility order? Should we vote to accept the application? Dr. Taylor, anything to add on that?
No, I think that's a great idea.
Okay. Ms.
The one thing
Coppin, you know this thing the best. What are the conditions that you would want?
Oh, you're asking me?
Yes.
I'm sorry. I saw Daryl's head go that way, and I'm like, since he's the beast, I just wanted to deflect to him, but he's the savage.
Ms. Coppin, I want to defer to you because you've been with this thing at the very beginning. So what?
Let's do a letter of completion. I love that. Also, letter of recommendation from her therapist when, and when she's back on her feet and feeling better. No pressure there. Positive energy hit it that way. And of course, I love the language about, her being compliant. Otherwise, if there is another arrest during that time frame, then it would be revoked. So that's my suggestions.
To clarify, you said letter of completion. What is that, and who's that from?
Probation, the probation office.
Okay.
Mm-hmm.
That will be a public document that we can pull offline. And so I would, instead of asking them to write something, there will be a discharge from probation that is a public document. And if they could just submit a public document, that might save a whole lot of effort and some bureaucrats working for county probation to have to actually write something from scratch. So if I could make that recommendation, just proof of completion.
Yeah. Would it be simpler just to get quarterly reports from her supervisor? That way we don't have to worry about the health of a third party that we don't have any control over, or her ability to find another therapist or any of those things. That way the supervisors that's a requirement. So I'm assuming you already have a supervisor lined up.
Yes, sir.
Great. So that makes it easy. Supervisors are used to doing that, and you can do that every 3 months for the first year of her internship or association.
Like that.
I like that. Thank you, Dr. Taylor. Anybody else have anything to add on this?
One question, Dr. Taylor, when you said report from supervisor, now that's going to be different from a report from her therapist.
Right. Well, just that instead of the report from the therapist. That way we don't have to worry about.
Okay.
Dr. Taylor, my concern would be a conflict of interest because as a supervisor, we can't provide therapy
to
our supervisees.
Not therapy. She's still doing therapy. She's doing her own therapy.
I understand, but I think what Ms. Campagnona brought up is the desire to see the progress in therapy, and supervision is different. We definitely want to progress supervision.
Right. Supervisors are logistically more attuned to doing this versus having some issue of counselor getting sick or inability to find a counselor or inability to pay for a counselor or inability to, whatever with a counselor. The supervisor is absolutely required to be present. So it's just an easier point of communication for us. Also, supervisors are used to doing this. We require it anytime we put somebody in probated suspension. So there's a ton of supervisors that are used to it. We can ask the supervisor to report on anything they'd like, but that just makes it easier. Therapists, I think it can be a little bit more difficult. It might take several months for a therapist to be comfortable saying this or that, while a supervisor can say, I have no concerns. I trust the supervisor. They've been a therapist for a long time. They have training. They know what they're looking at. It just makes it easier.
But if the eligibility order provides that the therapist can report to us that they're not progressing, that wouldn't come through the supervisor.
Right, but now we're ordering someone into therapy, which I don't personally, I don't really like, because I don't like to order people into therapy.
That's why the letter from her previous therapist or the current therapist is important.
I agree that's important, but I also understand this person has some health issues, and that seems to be a point of contention here.
This is Rodney Montes. Just really quickly, I mean, we can continue to ask Miss Woolley. I'm hoping she gets better, and I'm sure she'd be willing to write a letter for Miss Arian as soon as she can. We're happy to keep on with trying to get a letter from her. If something happens to her, obviously, then that's not the window. But then it would delay everything as far as getting another letter from another therapist.
Well, the problem is that if we put it in the order, then her license gets revoked. So if something were to happen to the therapist. So that's
sure,
kind of a rare outcome I'm trying to.
Unless you put like I mean, if that's really the concern, unless you do like within a year of the effectiveness of the order, there should be a letter from our current therapist indicating progress, or I'm not sure how you would word that, quite honestly, but
I've worded plenty. I've worded plenty.
I would kind of take and gratefully take Mr. Montes' offer to not so much order his client into therapy, but just document ongoing therapy that she's agreed to do. And if she's unable to get documentation from her previous therapist, if she's I mentioned earlier, she is in the process of seeing someone new, that we don't add a clinician's name. We just say that whoever care she's under at the time is able to provide us information about her progress, so that we don't lock her into a clinician that may be sick, but that we support her in her efforts for continued improvement of health.
Absolutely. And that's what I said earlier. If Tristan had started to see this therapist in January of 21, different ballgame. But because it goes back to 2018, there's a lot there. You know, there is rapport, there is a therapeutic relationship that has been established. So this person is a reliable source for us. So Daryl, where I can't see you, but help us with this. Help us find that medium, you know?
I'm viewing this, and we're starting to get pretty complicated here, but I'm viewing this as we have three conditions to begin. The verification, the completion of probation, and then we have an agreement on just a revocation for another DWI violation. And then there's this third part, and this third part kind of has a preference order. The letter of recommendation, or the first preference from the therapist that's been treating since 2018. And then failing that, we have the option of a letter of recommendation from the new therapist, which is, everybody has said, can vary in time length. And then failing that, we would accept the supervisor feedback. That's how I'm seeing this. And it is getting kind of complicated, but I view it as that addresses everybody's concerns.
Stephen, could there be something added to just to simplify it? If letter of reference, recommendation from therapist, or continued therapy with a new therapist, you know, as Dr. Taylor has mentioned. So that now gives her and or. Okay, so if this poor woman doesn't get better, again, we've all sent positive energy her way, then she has the option to do this. Does that help?
I'm fine with that, because I think that's kind of, if I'm reading this right, their first choice is they're hoping that the ongoing therapist is feeling better by Monday and is willing to get this letter, because that's the easiest way to take care of this. But failing that, I think what we would all like to see is, and know, is that Ms. Arian is not, since her former therapist or her current therapist is unavailable, that she's seeing a new one. And so I'm okay with the or, because I believe that, you know, they're hoping to knock this requirement out as simply as possible with a letter from the therapist that knows her well. So I'm okay with the or.
Okay.
Daryl, is this getting
I'm
too
also,
complicated, or can we handle it?
We can handle this. I'm a little fuzzy on the chain of command of, what's the first choice? It sounds like it's the existing therapist, the doctor that's sick. Then the fallback position is whoever she finds to take over therapy after the fact.
Once that therapist has seen her enough in order to feel comfortable making that letter of recommendation.
Okay, and then if she doesn't find somebody there, we want to just get a letter of recommendation from her supervisor.
That is very much in third place option.
And I would actually put that as an and instead of an or. The supervisor, it would be a current therapist or new therapist and supervisor, because like you guys said,
So
we
two
have,
letters.
yes, we have more interaction with that supervisor. Dr. Taylor said, they're used to doing that. That's a norm for them. So the or would just be between the two clinicians, and then it would be comma and supervisor.
Okay.
Okay.
what about the new therapist? How long would we want her to see that person? Or how many times?
I don't feel comfortable getting into the minutia of telling another clinician how to practice.
Yeah, I think
or
they
ordering
need.
somebody into a specific amount of time. I don't think
I
that's,
don't want to get into telling them, Chris, about the time.
Yes.
But at the same time, if someone's seen them 1 or 2 times, the research is not to say that a counseling relationship is established that fast.
right. I respect that, Dr. Bradley. I think the reason why we're reviewing this today is because she just didn't have a letter from the previous therapist.
I think
said that
that's
she was
true.
good to go. So if we can just get that resolved in a very quick and easy way, I think we can move forward. I fear we're going to get into the weeds here of trying to find a perfect set of variables. It's just a little too much, I think.
I wouldn't worry about the letter of rec from the supervisor, because you guys get that anyway at the end of the associate supervision. So we're kind of duplicating. We're going to know if the supervisor says this person ain't ready, she don't need to be fully licensed. You're going to know about that regardless of what you put in this order. So I think probably to simplify it, you can say a letter of rec from your current therapist, or another letter of rec has to be submitted within 1 year. And that way you've got plenty of time for them to establish the fiduciary relationship, the client-patient relationship there. Because really what we're saying in the order anyway is if you get a DWI conviction within a year, your license is gone. You're giving it up. So.
Okay, I'm ready for a motion. I'm not going to word it right, Daryl, because you're the savage and you're going to take that part, but I'm ready to do a motion.
Who will be writing the eligibility order?
Patrick. Or I guess Mary will.
Oh,
She
wait.
threw her hand up.
Wait.
Mary, that never.
I will defer to my boss. No, I'll be happy to draft it and I'll give it to Patrick.
Okay, so I will ask for a motion to approve Ms. Arian's application under the following conditions that will be spelled out in an eligibility order drafted by council, including we will require the verification of the completion of the probationary period. There is an agreed revocation for another DWI, a no questions asked, agreed revocation for another DWI violation. And then finally, a letter of recommendation from the current therapist, or within 1 year, a new letter of recommendation from a new therapist.
So move.
Second.
Okay. Ms. Campanone made the motion. Dr. Bradley seconded. All in favor, please raise your hand and signify aye.
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 Okay. Christina, that's Ms. Hall, did you vote aye?
Aye.
Okay. Then we'll show that is 9 in favor and none opposed. Attorney Montez, thank you very much for your time. Ms. Arian, thank you for being here today. I know that this can be some kind of an intimidating and stressful process. Thank you for coming here and speaking on behalf of yourself. Best of luck to you. We need lots of good counselors, and we're hoping that you will be one of them and do so soon.
Thank you all so much for your time.
Thank you very much.
Mr. Montez, before y'all go,
Yes.
Just so we understand that this is a conditional issuance of the license. In other words, your client would have to sign off on this. She'll have to agree to this eligibility order.
Sure. We
Okay.
understand. We understand.
Okay. I just want to make sure.
Yep.
Okay.
Thank you.
You
Okay.
bet.
Take care.
All right. They are gone. Thank you, everybody. Let's go ahead and move on to item number 6. Discussion and possible action on second quarter orders. Christina.
Yes, so the only one that we had for the second quarter, you guys did review, and it was executed at our last meeting. So we have no new orders for this quarter.
And I believe I've already signed that one, correct?
That is correct.
Okay. Number 7, orders on the second quarter executed by Executive Director.
Yes, so there were a total of 21 total orders that were executed by Executive Director Daryl Spinks. So those are just presented to the board for review for your information. Our attorneys have been trying to knock them out and get things taken care of. So for our second quarter, we had 21 total.
Okay. Anything to add? Any questions? Agenda item number 8, updated reports on annual enforcement actions, dismissal reports, and performance measures for the second quarter. Christina?
Yes, so you all have the dismissal report that you also received a supplemental on yesterday afternoon. So the dismissals, these ran from February 12th, which was the day of our last meeting, to yesterday, May 6th. They had a total of 336 total cases that were dismissed between February 12th and May 6th. So that's an amazing job that the enforcement department is doing, investigations, again, all of those staff just taking care of business. Did y'all have any questions on this report? It does look a little bit different. I think that they've realized the volume for LPC, and so they had to kind of simplify it a little bit more. So it doesn't have everything spelled out like before. But again, you know, the staff are working really hard to make sure these are getting done and reviewed, you know, how they need to. Next report we have is the Bheck performance measures. I did provide this one for you guys so that you could see the licensing part of it as well. You can see how many licenses were renewed for LPC. It's an overall picture for all of the Bheck programs as well as just for LPC. And the second page talks about the complaints. So it's just a little bit of extra information for the board related to the Bheck issues. And then the last one is, which I'm gonna try and share screen on this one. See if I can do that. This is the Hex Status Report. And let's see if I can do share screen. Can you guys see that page? The status report? Let's see.
Now we can.
Okay. So the big thing that I wanted to point out here, which I thought was amazing, if you guys look at the fourth quarter for fiscal year 20, under pending complaints per board by the member board, LPC started at 846 cases when we first came over to Bheck agency. If you look at for our third quarter for FY21, we are at 477. So it's just having the resources and the staff, I mean, they are giving their all and taking care of business and getting the cases resolved. So kudos to all of the enforcement investigators who are working on getting these, the attorneys on getting everything, you know, where we need to, the direction we need to be heading.
I would like to commend the Bheck staff for getting the number of pending complaints under 1,000. That's a job well done. So great work to everybody that tackled that. It's fantastic to see that number dip down below 4 digits.
Correct.
Mhm.
So they'll keep pushing through, and you know, I'm sure, you know, the thing that we have to remember is cases keep coming in. So even though they're getting them resolved, more coming in, and so it's, you know, it's trying to get them resolved as they come in, which we are, you know, our staff are doing that, but they have been giving it their all. So I wanted to make a point of that, and thank you, Chair Hallbauer, for saying that, because I know it means a lot to them as well.
Mhm.
Do you guys have any questions on this report at all? These are our SOA cases.
I don't think so. I would say keep up the good work. We're heading in the right direction.
Yep.
Hey, Christina, what's the comparison for the SOA cases? That is a nice photo. The SOA cases from this year to last year. Have we seen a significant increase in cases going to SOA or a decrease in cases going to SOA?
If you're talking about like what's being scheduled, I would say yes, absolutely. They are being, now they're being scheduled. You know, I can't really speak as to the delay before. It could really just be staffing. But you know, we were sharing attorneys with, you know, it was HHSC attorneys. It wasn't just the board attorneys. So trying to get those scheduled versus now we have, you know, 2 attorneys who were assigned strictly to LPC. And I can say that to me, I'm so grateful that we have these attorneys because they work really hard on getting these done. And, you know, I feel like it's a great team with the board members and these attorneys. So we're really lucky to have them as well.
Yeah, we are. So my question is, are we seeing more of our cases go to SOA or fewer of our cases go to SOA with the new system that we're doing?
Sure. So our agenda item number 9, you know, I can jump into that real quick if you want me to. We currently have 2, there were 2 that were scheduled, but the respondent decided that he wasn't going to move forward with the SOA cases because they were already scheduled. So he surrendered his license, and that resolved, I think it was 3, I think, Mary, I think you had that, or no, it was Rayanne. I think that person had 3 or 4 cases that were open. So that resolved those cases with a surrender. They have 1 pending scheduling to SOA right now, and then 1 that has been filed to SOA right now. So that's you know, a big change from what we were seeing before. And yeah, so.
All right. Well, shout out to Mary and Ray and great work, crew.
Absolutely.
Dr. Taylor, is what you're asking is the new method of handling like ISCs, is that generating more SOA bound complaints than the way you used to handle it? Is that what you're asking?
Yeah, that's what I'm asking.
Yeah, we don't have any, we can't tell that right now.
Gotcha.
From anything, because most of the stuff that's going over, Patrick, correct me if I'm wrong, most of the stuff all the stuff that's going to SOA right now is all the really old stuff.
Yeah, I mean, most of it I think is stuff that was maybe previously reviewed, although some of them they're doing new ISCs because they're maybe very old and docketing them. It's hard for me to compare what was done previously since not being a part of what was done, but I will say things are getting docketed at SOA. I don't think that they've had to litigate a full case yet because there's nothing like having a pending court date to make people settle. So they are docketing cases at SOA. And once that happens, people are more willing to settle things. So I don't know. It's hard. Yeah, it's hard for us to compare what it was, but a lot of it is what was done before. But a lot of it is older cases that are just needing to be cleared up. And I know not in that report, a particular case where a respondent had about 5 cases some had been reviewed at ISC, and then they had to have a new ISC for some of the new cases, and it got docketed. Got docketed, and the person then, ended up surrendering their license. So we'll dismiss it without having a hearing. So I don't know if that helps answer your question, but at least gives you a little bit of background.
Christina, is there anything else to address with number 9, the SOA cases?
That was all for the SOA cases as well.
Okay, great. Let's go ahead and take a look at agenda item number 10. This is discussion, possible action on areas for standardization with other member boards. Tuesday's meeting at Bheck, we agreed to Dr. Taylor, to his credit, had suggested that an ad hoc committee be formed with Bheck members in order to identify areas of standardization across the member boards. And frankly, if you suggest a new committee, you better be willing to join it. And to Dr. Taylor's credit, he was. And so on this new Bheck ad hoc committee, we have already 3 board members, Dr. Taylor from LPC, and then we have, correct me if I'm wrong, psychology and social work, and we were working on a member from LMFT. Do I have that correct?
We had LMFT. It was Janine Smith, and then we had psychology,
Susan Fletcher.
Susan Fletcher, and then we just kind of appointed the social work board member because he wasn't present. So
yes, never.
Yeah.
I'm sure he'll be excited about that.
Never miss a meeting, Dr. Amunia, or you will be on all kinds of committees.
Okay, this is.
Would you like me to share the screen of the items? I'm not sure if it was available to you guys. I couldn't open it.
I know you had sent an updated. I had one that had 4 items, and now we're up to 8. Okay.
I'm gonna share screen for you.
Go
guys.
ahead and share the screen. I'll talk a little bit more. The role of the ad hoc committee is to start the discussion with the member boards on, okay, we have rules that aren't the same between this board and that board. Okay, other board, why do you do it your way? These are all, we have a running list right here of 8 items that are somewhat in conflict and identified as areas to where we're going to start discussion and figure out what can change be made, because we don't know why social work does some of the things that they do, and it'll be the same for us. We have to explain why we have our deadlines or why we have this requirement. This committee is expected to last a while. And we're not talking months, we're talking in years. And so even the committee is ad hoc, it's kind of open-ended at the moment. And this is the initial work that's been identified that we're going to get started on. And Christina, I think the best way to handle this is tell the board members that if you have other ideas on here that you would like to see, go ahead and submit them to you, and that you will coordinate relaying that over to Dr. Taylor. I don't think that we have a start date for the first meeting of the ad hoc committee, but it's now, apparently some people don't even know that they're on the committee, so we're gonna have to notify them before we can start scheduling it. But Daryl, what are we looking for? A member from each of the board and then some stakeholder input?
Yes, sir. Yeah, what we're going to do now, and I've already started it. I started it yesterday. We will try to figure out which stakeholder, which state associations we want to send an invitation to participate on the committee, and if we want to use any members at large, i.e. individuals who are not designated by a state association. Once we get those identified, we'll bring them all together in an organizational meeting, figure out how we're going to operate the committee. Obviously, the council members that were appointed, they're going to be the ones in charge of everything. And then we'll start trying to identify what are some areas that we think could be standardized across the board, across all 4 boards. And that's, what I told the council is this is going to be a very long process. It took us 2 years to overhaul just the supervision rules in psychology. I envision this to be a 3 to 4 year endeavor. Now, I don't think you'll have to wait to the very end of the 4 years to start seeing the fruits of your labor here. I think you're going to start some items that we can identify, we can begin implementing along the way. But I think everybody just needs to settle in. If you're an applicant out there waiting for some form of standardization, don't wait, because it may be 4 years, before something ever happens, if it ever happens. Again, another reason it's going to take so long is a lot of the issues we're going to be tackling with are going to have to originate with your board. Bheck is not going to be able to just say, well, we want this the same across the board, all of you, this is the new law. A lot of these changes may have to originate with you. So we've got to convince each board this is a good idea to standardize in this area. And that's just going to take time to do. So,
Daryl, what sort of changes would require statutory change?
Not a lot of these that are on here would require a statutory change. If we were going to say change, and I'm not recommending this, or I'm just throwing it out there. If we were going to say we want the same amount of supervised experience for all the boards, y'all have 3,000 hours, psych has 3,500, social work has 3,000, I believe, for their LCSW, and I forget MFT's got 3,000. If we wanted to standardize that across the board, there would need to be some statutory changes in there.
Okay.
But what we're talking about here is we're only talking about changing what we can change through our rules. We're not talking about working up statutory changes and then go over to the ledge and try to get them to do it. That's way beyond the pale of this committee. So
the reason why I was asking is because we've already established that this is going to be a long-term committee. And so we do need to think long-term, as in the next session, so that
yes,
we prepared for the session. The bill's filed early, so we're not just kind of trying to haphazardly rush something through. We've got a plan for 2 years from now for the changes that we would like to see made.
Yes.
Okay. So board, this is one of those rare things that seems like very good. And standardization was one of the goals of Bheck, and now we've begun the process to really implement those objectives. So again, thank you, Dr. Taylor, for being willing to tackle this. But everybody, it's not just what he wants. It's ideas can be funneled over to Christina, and then she'll relay those to Dr. Taylor. And there's 9 of us, so if something stands out that nobody has noticed, feel free to suggest it. So this is one. I'm excited about this one. We are seeing we're kind of Bheck is kind of in place now. Now we're starting to tweak the engine and see what it can really do. Okay. Any questions? Any comments on that?
No, I'm really excited to be a part of it, and I most definitely looking forward to making Daryl's life harder. The more work I can make for you, Daryl, that's just like icing on my cake, man.
It's working with you mental health providers is why I have all this gray in my hair.
I bet.
So just a reminder, members, if you think of any ideas, just send them to me so that I can get them to Dr. Taylor.
But yeah, I'm most excited about this because I think it's going to be a great step forward for us as a profession as a whole, just to kind of get more in line with each other. So it's not so confusing when telehealth changes or CEs change or something. It's just much easier for people to be duly licensed, much easier for the public to understand. It's much easier for us to understand. It's just going to be better for everybody. So I'm very excited.
There's a good byproduct. Even if you don't achieve standardization in some identified area, it's beneficial to the public to understand why the boards view it in a different way. If you choose not to standardize in that particular area, it also helps the staff. So this is kind of it's a twofold project. The goal is to achieve standardization and efficiency where we can. Where we can't, it also helps explain why we can't or why we shouldn't do it in that area. So.
All right. Okay, we're about an hour and a half in. I'd like to take a 5-minute break at this point. So everybody go fill up your coffee. Let's meet back here in 5 minutes, and then we will move on to item number 11. See you in a minute.
Right.
Okay, we are now, we're back from our break. We're now on agenda item 11. This is executive session. The board will now go into closed session at this time pursuant to the Texas Open Meetings Act on agenda item 12B in order to receive legal advice from its attorney under section 551.071 of the Act. To all members of the public in attendance, you may stay logged into this Zoom meeting. The board members will leave, and once the board's closed session is finished, the board will rejoin this Zoom meeting. The date and time is May 7th, 2021 at 10:42 a.m.
Okay, so board members, I just sent you an email right now with the new link. You will log off of this Zoom meeting and log into the new one. Once we finish executive session, you will log out of that one and you will log back into this one. Okay?
Okay. See everybody on the other side.
And Daryl, I'm gonna put this on pause again. Right, okay.
Yeah, you pause it and you leave yours running, Christina.
Okay. Okay.
The board is now reconvened in open session at May 7th, 2021 at 11:51 a.m. We will now move on to agenda item 12A, the Professional Development Committee report. Janie, I think you're going to give us that.
Chair Halbauer, the Professional Development Committee met together to discuss kind of a comparison contrast between the two exams that are used for licensure, and the conclusion was that the two exams are meet their function of determining readiness in terms of understanding theory, but have nothing to do with operating practice.
Any questions on professional development report? Okay. Go ahead and move on to agenda item 12B. This is the Rules Committee report regarding proposed changes to board rules. Rules Committee met, and prior to the meeting, we let our stakeholder organizations know that we wanted to hear their opinion on proposed rule changes. We offered them 5 minutes of open comment. We also encouraged them to submit written comment. We heard from LPC Associates of Texas, Christian Counselors of Texas, TASIS, and TCA. Board, you do have their, the ones that submitted written comment on their position. You do have that in your meeting packet materials. I'll briefly summarize their positions here for you. LPC Associates of Texas submitted written comment and spoke at the Rules Committee meeting. Unsurprisingly, they are in favor of both proposed rule changes. They are very clear that any rule change will not change the supervision hours requirement, and that any change should not force supervisors to supervise an associate that owns a private practice if the supervisor does not want to do so. Christian Counselors of Texas submitted written comment and spoke at the Rules Committee meeting. They are opposed to both of the proposed rule changes, citing concerns about the time and energy that have to be put into both starting a counseling career and launching a new business, and how it increases the likelihood that the associate will make mistakes. In addition, Christian counselors indicated concern about the associate's loss of liability protection if the rule change was made, and observed that if the true problem lies with bad supervisors, that fixing supervisors should be the focus. TASIS did not submit written comment, but indicated that they concurred with the written comment submitted by TCA. They did, however, speak at the Rules Committee meeting and expressed support for the rule change, allowing direct billing, as well as support for associates to own an independent practice, provided there were additional clarifications enacted. And finally, TCA submitted written comment and spoke at the Rules Committee meeting. TCA expressed strong support for a rule change that would permit associates to accept direct payment. Regarding a rule change that would permit associates to own independent practices, TCA supports the rule change with additional safeguards clarified, including clear delineations on supervisor liability. Rules Committee then proceeded to discuss for the following few hours after the stakeholder presentations. A lot of the discussion was focused on if the rule change was made, what are the stipulations that would be required? What would the board want to see that would continue the protections for the things that they're concerned about? We did identify stipulations that we wanted to see, and those were added into the changes that legal counsel put together and sent to us for our consideration today. So, Ms. Stubblefield, Dr. Taylor, is there anything that you want to add regarding our discussion from the Rules Committee meeting?
I just said it was a wonderful discussion and appreciated everyone's input. To echo what you said earlier, Steve, there were a lot of comments, wonderful, wonderful comments. And we have read them all and reviewed them all, and we appreciate that input.
Okay. Ms. Stubblefield, anything to add?
Sorry. From the Rules Committee, there has been a lot of discussion. And because I have a couple screens up, the support letters that you just read, I'm concerned about some of the vocabulary because you're saying TCA supports that LPC associates could own and operate an independent practice, but we're defining an independent practice as without the supervision of an LPCS. And so I'm concerned that, I don't know, that was not my take from that Rules Committee meeting, that LPC associates would be without supervision.
No, the supervision requirement is, I may have described that incorrectly. There is no change to the supervision requirements.
Because the how we're defining independent practice in this rule change is without the supervision of an LPCS.
For the business practices.
It is 681.2 definition. 13, independent practice, the practice of providing professional counseling services to a client without the supervision of an LPCS.
But the rule changes do not provide for independent practice for LPC associates, just the ability to own individually a business. Very important distinction there. None of these rule changes are granting independent practice to LPC associates under any circumstances or conditions.
Okay, but if our stakeholders are saying that's my question is, what are the stakeholders supporting? Because if they're supporting independent practice as we're defining it without supervision, I just want to make sure that we're understanding that that's what they're supporting.
No, that was not my intent to say that they would not be supervised. I was saying that there would be the owning their own business.
I'm talking to the letter from TCA. Is that what TCA is saying?
I did not read their letter to support independent practice.
No stakeholder in support has been in support of anyone doing therapy without supervision. So
correct.
That's not.
Yeah, if I was vague on that, I apologize. That was not my intent. No, nobody's in support of removing the 3,000 hours of supervision requirement. Let's be very clear on that.
We can't. It's statutory, so that's not going anywhere.
I apologize. That was not what I was trying to convey there. I was trying to convey that there is support for associates owning their practice, but no, the supervision hours is still required. And LPC Associates of Texas, they make that very clear. They want everyone to know that they do not want the supervision requirements changed. Okay. There are many different factors associated with this rule change. And so this is the time where we will discuss those other factors are in play. The biggest question is, if we made this rule change, does it present a risk to the public? So those of you that have concerns about this rule change presents a risk to the public, go ahead and speak and explain why you think so, and any sort of support that you have for your argument. This is the time to say so.
Are you asking for public comment?
No, I'm asking for the board comment. Anyone that feels as though, for you, for what you personally feel, professional member or public member, if you feel as though this is just too far, I think that making this change creates a risk to the public. I mean, that is job number one of our description on this board: protect the public. So if you feel as though if we made this rule change, it presents an unreasonable, or I've used the term a material risk to the public, then this is where you state that and explain why you believe that it does. Because that's job number one for us, is protecting the public. And
I will share, and I shared this in the Rules Committee. Part of my concern is that the 3,000 hours of supervision is a season for professional counselors to become well-grounded in their therapeutic practice. That the academic years is focused on academic theory. That the supervision season, however long that is for an individual, and it can be as little as 18 months up to 5 years. But that supervision season is intended to be to focus on clinical skills. And so this is what I said publicly in that Rules Committee, is that I think we need to maintain the limit of that scope on those clinical the focus being on developing those clinical skills.
okay.
And our licenses clearly state that then once you're fully licensed, that limitation of focus is no longer imposed because you're no longer under supervision.
Okay. Ms. Campanone, did you want to speak?
Yes, so I feel that, and I've said this before, we cannot keep anyone from starting a business, just period, just in general. Anyone can start any LLC that they want to. But as it relates to this, because, there is this agreement between the LPCS and the LPC associate. And that agreement, again, 18 months, 2 years, 3 years, whatever duration it takes for them to fulfill those hours, is an agreement. And within that understanding is, if you are going to have your own business and you're going to be billing or charging or whatever it is that you're doing, that is an agreement from the very beginning between both parties, and that it is in the full authority of the LPCS to be able to oversee that, to be comfortable with it, and to just ensure, again, that you are getting the clinical skills. And that, if that's 18 months to 3 years, fine. But I would like to see LPC associates receive all the clinical skills that they can get before they become fully licensed. So again, I think what it comes down to is you have an agreement, make sure that we have oversight on those things, period.
Okay.
I would just kind of add that just from my experience, it seems that the 3,000 hour period is an opportunity to learn. It's not meant to be punitive, it's not meant to be harmful, it's not meant to cause undue burden. But as gatekeepers of our field, we place this time frame of protective learning on LPC associates so that you can make mistakes, you can, do what you need to do under the guidance and help of someone who's been down that road before. And so I think that whatever measures we take, that we get back to that foundation of essentially these rules were established with regard to supervision so that someone can have that practical application under the guidance of protection from someone who's been down that road.
Thank you, Dr. Amuna. Dr. Taylor, Dr. Bradley, I'd like to hear from our professional members. So
I'll speak. I'm not against this, but I do have some concerns. And that is when counselor ed programs, okay, the student graduates, this has ramifications for counselor education programs to be aware. Some of the things that I think they need to be aware, more intense record keeping. Because I think when we place that student with a master's degree out, there are some students that have had some experience, but there are some students that are brand new to the field. So I would like to see, I'd like to hear us discuss how we think this will change or should change the training of those students before they go out.
okay. Dr. Taylor?
Yes, Mr. Chair, were you just talking about harm to the public? Is that it? And that was your specific question.
I think that's our first one of our factors that we need to consider on this.
Yeah, that was your specific question.
Yeah. Do you believe this presents an increased risk of harm to the public?
From the data we looked at, there's no argument to support that.
Data being
The complaints that we looked at and what we discussed in the last meetings, I mean, there was nothing to support an increase in harm to the public.
Well, you mentioned that, and I view it as we can obtain data from two different sources. First of all, we can see what the other member boards are doing. We can see if there have been issues for other boards that allow this, and we can also compare with other states.
Right.
So as Daryl eloquently put it, we have not had the parade of horribles from LMFT, which allows this. And we have done a pretty in-depth dive into how other states have handled this.
Mm-hmm.
We don't have a comparable reference point that indicates that there has been an increase in complaints after a state board began to allow this, to allow direct billing and owning the practice.
That is correct.
Okay, so in the absence of data that this has created an increase of public, I would ask the board, do you have any other sources for where you believe that we could obtain data that would support that there is an increased risk to the public? Because absent any other sources, we are left with the best we have available. And that's kind of taking a look at our cousins and LMFT, see what's happening there, and taking a look at other states and that have done this and the results that they have had. We've done that. That was part of the Rules Committee. Christina did a very thorough job with reaching out to the boards of other states. We haven't found the data that indicates that there is an increased risk of harm to the public. There's not been, in states that made this change, have not had an increase of complaints. So in the absence of solid data, and we're working with the best we have. We have what our sister boards are doing, what other states are doing. That's the best that we have, unless y'all can show me otherwise. But in the absence of data to fall back on, we kind of coalesce around regarding risk to the public. We sort of fall back on this position of it just feels risky. And that's what, to me, I think we need more than it just feels risky. And I am a public member, and I do want to hear how the other public members view it. But just looking at it, an attorney standpoint, I would want to see evidence that this change, should it be made, is for sure going to create an increase to the public, or might increase a risk to the public, because the data that we have indicates that it's not going to. So if you have more, then I want to hear it. I want public members, professional members, either one. I want to hear it. I think this is the threat to the public factor needs support, even if it's just, even if you have a personal anecdote about it.
Stephen, this is Loretta. I agree. I looked at all of that data, and the evidence is not there to say they're likely to create harm. The only other source, and I'm not sure that we'd want to go there, would be a large liability insurance company. Where are their claims coming from? Are they coming from the associate, or are they coming from a fully licensed? And I'm not sure that we can get that information, but that is something that might lend us some information.
Yeah.
If claims are being paid out, are they being paid out to a particular group of insurance carriers? I don't know. I know TCA and ACA endorse HIPSO, but there are other carriers. So I don't know that this task is even feasible. But that's the only other third source I can think of.
And Dr. Bradley, I think that's a great idea. The probably the fact that the premiums for associates are like 10 times less than they are for fully licensed people might speak to the fact that there are far fewer claims, that maybe none at all, or very, very low amount. And the fact that our complaints as well are extremely low for associates, and majority of them are typically interpersonal disputes between them and their supervisor.
Okay.
As an LPCS, it gives me comfort to be able to know that should I decide to supervise an LPC associate, that we are going to take this day by day, week by week. There will definitely be a lot of oversight to benefit this individual, to help them become fully licensed, to help them grow. So at the end of the day, the burden falls on an LPCS. Really, it's us. We're overseeing this. We need to ensure that everything is being followed accordingly. That's why they chose us as supervisors, because they entrust us to be able to see and to guide them. Okay, well, let's try doing this, or how comfortable are you now that you have this business? How comfortable are you? So that gives me comfort as an LPCS to know that I can navigate this if I feel like it's not going quite where it needs to, period.
Okay. Public members, can I get your thoughts on this? If you were just completely removed from the situation and this rule change was presented to you, what concerns do you have? What concern, if you were to, if you were meeting with an LPC associate and they explained, I have my own business, however, I'm still supervised, and here's the name of my supervisor. They monitor my practice, however, they are not involved on my business side. So public members, Pastor Roy, Mr. Nairn, Ms. Hall, does that give you pause? Does it bring in questions? The beauty of the public members here is to bring in the outside perspective, to kind of have this clear mind when you take a look at a situation, because our professional members have just tons and tons of experience and they know how things have been done, but they don't have that outside perspective. So Pastor Roy, go ahead.
The confidence, I appreciate that. The confidence that I would have would be in the supervisor, not so much in the licensee or the intern, because the navigation would depend on, there's a biblical text that says when a student is fully taught, they will be like their teacher. So the confidence that I would possess would be in the supervisor. And if the supervisor is complete and a good instructor, then I don't really have any worries that everything else would fall in line as well. So I don't really have a great concern there if the supervisor is what they're supposed to be.
Well, you're making a good point, because part of what we hadn't really gotten into yet is this does require an affirmative confirmation from the supervisor that they are comfortable and they accept this relationship.
Absolutely, I agree.
Okay, so are you, if I understand you clearly, if the supervisor has accepted the relationship, that's enough for you to be comfortable with it?
Yes, as long as I have confidence in that supervisor, I feel completely that everything is in control.
Okay. Mr. Nairn, do you want anything that you've been involved with this through, you've seen a lot of the sausage being made here as a member of the Rules Committee. Where are you on this, and has your position changed or evolved since this was first brought up and through the Rules Committee meeting and hearing from the stakeholders?
Yeah, I mean, Chairman, I'm all for folks having their own business. I think that's incredibly important and a great thing. From a public member's perspective, I do question Kathleen Mills. I have in my notes said on a meeting last, if providing this access hurts or helps Joe Citizen, and if it hurts, then not for it. So I go back and forth, because while someone I forgot who said it, but not everyone is, 23 years old that's doing this and have run other businesses before. And I go back to that, but that's not all the folks we're talking about as well. And so to answer your question directly, I'm still kind of in the middle. I don't know if I feel strongly convicted one way or the other.
What would you like to see addressed before you would go one way or the other?
I'm not sure. I wish I knew that.
Okay.
But the discussion helps. The discussion helps, and just hearing from our professional members helps me, at least, because like you said, I'm coming from a blank slate. So hearing the different opinions of our professional members educates me further. And so I think that discussion, the further we get along, the closer I get, for sure. And that helps.
Well, for me, if I were to just kind of be sitting in on this Zoom, my tainted attorney brain wants to hear evidence. I want to hear the reasoning. Yeah, everybody can have an opinion, but I want to know the support behind your opinion. And for me as a public member, I keep coming around to the fact that the closest comparisons we have on this has not shown there to be an increased danger to the public. That, for me, that's what I keep coming back to, because again, job number one, protect the public. And And that's what I always, anything on the board, that's always what I have in mind. Ms. Hall, anything to add from the public member perspective?
No, I think my thoughts would be mostly subjective. I think I really hearken to what you're saying. To me, I juxtapose the evidence, which is factual, it's based, it's legal, versus my opinion or how I feel subjectively about the subject. And right now, I feel certain ways about it, but it's mostly subjective. I don't think I can weigh in on the evidence or the legal aspect because I just don't have that type of competence. And if I were seeing a counselor or a licensed counselor, I think I have protocols that I can exercise if I'm not comfortable with something. Even if we don't execute a new rule, I think I know I have protocols that I can opt into if I'm uncomfortable or if anything is not feeling well for me as a client, if that makes sense.
Okay. Public members, do you think that for the public walks in, the LPC associate explains the relationship, do you think that members of the public are really thrown off once they explain that relationship? So they walk in the door to the practice, the LPC associate explains, hey, I own this business. However, I'm not fully licensed. I'm supervised by this person. Does that, I guess, erode the confidence that that member of the public might have with that associate that they just walked in the door and wanted to speak with?
Affected to me that much because I see and have seen a PA as my doctor for many, many years. It's not so much that I trust the PA, but I do trust the doctor that he studies under. So he has treated me with no problem for 15 years or so, and I have had no problems with my PA navigating my healthcare. So in this arena that you propose, I don't have a problem there either if the supervisor is competent and on hands with the intern.
Pastor Smith, to that, is your PA in the doctor's office?
He is.
Okay, that's what we're talking about, is the associate would not be in that supervisor's office. They'd be anywhere else.
Right. But the in my dealings with them, though the doctor is present in the office with him, the doctor is not over his shoulder. He's in the office with him, but he's not there watching his every move. Matter of fact, there are weeks at a time when the doctor is not there at all, but the PA is.
But the doctor could open your file and read it at any time.
At any time, yes.
Yeah, and what we're talking about is having that separation where the associate has their own business and the supervisor is not a part of those files and all that kind of stuff.
Okay, I guess then I'm misunderstanding the concept of the supervisor.
For the direct counseling services.
But I'm sorry, I need to interject here. I know that as an LPCS, when I am supervising an associate, I tell them always, after any time of meeting with them, I tell them anything comes up during the week, day or night, 24/7, you call me. You're uncertain about something, you call me, because if you don't, I'm going to hold you accountable for that, because I'm giving you myself 24/7. But I think what Pastor Smith is saying is, at the end of the day, there's two things, or one thing that's very similar is, even though that person is under the practice of the doctor, but this associate is not, they do have one thing in common, the liability. So we as LPCSs will hold that liability. So does that doctor. And so I think when I initially go to see the PA, I know that there's an oversight. And so when they come to see an LPC associate, there's an oversight. Now the business aspect of it may be different.
Absolutely.
That's correct. We do separate liability for the business practices from liability for direct counseling services. That does not change. The supervisor still has the liability on direct counseling services. Dr. Amuna, I'd like to hear your thoughts on this. You're new to the situation. And correct me, did you move into Texas from out of state?
I did about 5 years ago.
Okay, where did you come from?
From Georgia and South Carolina.
Okay. Any perspective that you have from before moving to Texas? We'd love to hear it.
Well, I would just being new to this matter, I would say the things that kind of come to my mind is that I'm being in academia. So being on a college campus as a supervisor, it is my day-to-day reality that I could possibly supervise someone who does not work at my university, right? So if I'm a professor and I'm teaching and I have someone under me, they may work for, mobile crisis unit, and I'm not there with them, but I'm their supervisor, if that makes sense. And so at least in Georgia, that establishment is already there, that I may physically be here teaching classes and you're not teaching classes with me. You're doing mental health at whatever establishment that you've gotten to get your direct hours in. And so even if they're at, behavioral health center, their cards will still have my name, even though I'm not associated with that company. Their cards and their paperwork and their notes will all have my name. And so we're in two separate locations. So whoever is seeing them knows that they're working for a behavioral health center, but they're supervised by Dr. Muna, who is over here at Texas A&M University. And so I'm used to that separation, but I can understand some discomfort if that's not been an established norm. And then there's also, as a supervisor, it's like, again, do you want to take on that liability of someone potentially associating you with that person's business instead of just their counseling? So if that business of that associate goes awry for fraud or embezzlement or anything, even though you're not a part of that practice, because your name is tied to supervision, that could hurt your reputation a little bit. So I see both sides coming in this kind of late in the game. I don't think there'll be a harm to our community having more people to provide service, because we need it. We need more people to provide service. And right now, LPC associates are providing services to individuals, right? They're providing a service. They're doing one-on-one service. They're just not able to financially benefit from the work that they are doing. So whether this rule is established or not, like in a sense of their own business, So whether the rule is established or not, they're gonna go somewhere and provide a service to someone. It's just a matter of whether they're doing that under their supervisor's business or under their own business. But to the public, it's gonna still look the same with regard to the service being provided.
Thank you. Okay, anyone else that wants to kind of comment on risk to the public, or we've started kind of getting into the delineations on liability for business practices and records. That was a clear stipulation that the Rules Committee wanted. The way we phrased it was if we had to make this rule change, then what would we absolutely, what were we very adamant about that we wanted included with the change? And Rules Committee had identified, first of all, we definitely want the supervisors to definitively acknowledge that they are accepting of the relationship. We've got that added in. And then we also wanted a clear separation of liability for business practices, but not the removal of liability for the direct counseling services. That's absolutely clear. Supervisors are still liable for direct counseling services. And those were two very important considerations that we had, that we added after the Rules Committee and Council added into what we're considering. And again, I think I know LPC associates, they've just stressed repeatedly that supervisors do not have to accept this arrangement if they don't want to. This is just permitting. It's more of an allowance. It's kind of like removing a barrier for those that are interested in pursuing it. For associates, it removes the barrier that would allow them to direct bill and own their own business. And for supervisors, it would allow any of them that want to do it, they would be able to undertake this type of supervisory relationship, but they don't have to. It will not be forced upon them. And that should be very clear.
Are there any protections for the LPC supervisor in the sense that if I start to supervise you and you don't have a business and along the way you establish one, that I can write into the board and say, hey, I started this relationship. This was not a situation. Now they've started it. And I want to remove myself from this person as a protection for me. Are there caveats along the way that where we don't do undue harm to the associate, but we still make sure that we offer all the protections we can to the supervisors?
Go ahead, Patrick.
I think in the proposed 681.93, it talks about adding, so in subsection A, it talks about the supervisor must keep a supervisor written record and what must be in it. And so in A1G, it says an acknowledgement of the supervisee is self-employed if applicable. So if that comes up later, if they form their own company and want to operate through it, it's going to have to be agreed to in that supervisory record. And if the supervisor and supervisee don't agree to it, the supervisor can terminate the supervision agreement and that's it. So the short answer is yes, I think it addresses it, but
thank you.
All right, is there any other comment or anything that anybody wants to add just along the lines of being for it, being against it, questions that you have about it? Because if we don't have other comments on this, I'm going to ask Patrick to kind of explain timeframes to everyone. Okay, hearing none. Patrick,
Yes,
can
I
you
just, my last comment would be, I wish all parties certainly felt the sense of comfort that we did, and I shared that like when we adopted having everything videoed.
I understand. Patrick, can you explain for everybody procedurally how the rule change works? Like
sure.
Whatever decision is made today, how that goes to Bheck and then back to the Texas Register. We explained that timeline for everybody on the Zoom today.
Sure. So what will, if the board decides to propose a rule change or changes today, what will happen is the proposed recommendation will go to the Behavioral Health Executive Council for consideration. That the next time that they meet will be in August of this year. They will review that.
Would people be allowed to make comment about this change for the Bheck meeting?
People can appear at that meeting and make public comments during that meeting and they can always submit your written comment to this agency as well anytime during it. But if then after the council reviews that proposal, it will then get published as a proposed change, not a final change, but a proposed change that then will go to, well, first it will need to get some further review, but it'll eventually get published in the Texas Register. And the Texas Register will then, during that period of that 30-day period of time, we will specifically solicit public comment. You can still submit public comment before that, but you can certainly submit it. There's an email address on the board's website, and I believe it's the rules at bheck.texas.gov email address. And if you submit it during that period of time, we will, if later we adopt the rule, we will have to respond to those particular comments in our adoption order. So there will be multiple stages where they can comment on the proposed rule. But once the proposal period is done, that rule will then need to come back to the LPC board to consider the comments and the proposed rules and determine whether or not they want to make changes or they want to adopt it as is, and to potentially respond to some of those comments. That the next LPC board meeting will be in September, but I don't know with the August date of Bheck that we'll have closed the comment period time. So most likely it'll be the November one, I think, will be when it would potentially be re-reviewed. And then at that point, the LPC board, if it chooses to do so at that time, can recommend adoption to the Executive Council, which will then meet again, the next meeting after that would be in February. And then they would then, if they accept it, adopt the rule, publish it in the Texas Register, and then at that point, it will be a final rule. It won't be effective until it is finally adopted by the council.
Okay, so there will be opportunities to tweak this, to make it, if something that hadn't been identified comes up, we can address it. This is not, if we voted to make this change, it's not effective at 4 o'clock this afternoon.
Correct. And the purpose of the rulemaking procedure is to solicit public comment in order to address potential issues so that the rule could address those or change those.
Okay. Does anybody have questions on that?
So Stephen and Patrick, so in that process, if we move forward, propose the rule change, would it give the Rules Committee an opportunity to be able to get together and maybe tweak a little more if they need to? I think that's what he was asking. I didn't get a clear answer on that.
Okay, one of the options you can also do today is you can recommend the proposal of these rules to the council, and you can also take these rules under further advisory, send them to the Rules Committee for potential further development so that they can look at them, and as they're workshopping them, they can discover some issue that they had not thought of before. And then when all those things come back, they can take all those comments and then re-propose the rules with additional changes. So you could go 2 tracks where you could still be looking at the rule and workshopping it. And if you discover something different or something you want to change, you could do another proposal, but you have one already in the works that unless you can see a reason that some big issue, you wouldn't need to pull it down. You could move forward with it. I hope I explained that correctly, but.
So it would move forward to Bheck in August, but if the Rules Committee gets together in workshops and discusses and wants to tweak something, they can forward that to Bheck, or would we come back together as a board again?
So we would need to come back together as a board. What you can do is do a quick meeting to say, look, the Rules Committee identified this big issue. We would like to withdraw what we previously proposed to the council. Just consider that one particular rule, send it to Bheck before their August meeting, and then it could run through that August meeting as well. So,
right.
Thank you.
I kind of view it as if we decide that we're going to get engaged, we're going to talk about a prenup. That's kind of that's how I'm viewing this. Is we can decide to get engaged and take some beautiful pictures, but we're going to talk about a prenup. That's how I'm kind of viewing this. And does anybody have a problem with that analogy?
Way to take the romance out of it.
I do family law, Mr. Spinks. Okay, so I have a feeling that that's going to be a popular alternative. So let's kind of keep that in mind. Anybody else? Further comment on this? Like I said, we're kind of voting on whether we want to get engaged.
Mm-hmm.
I think it makes it. Oh.
I'm sorry. I just wanted to hear from Janie and Dr. Taylor, who are in the Rules Committee. Just, what are your thoughts on that?
Which part specifically, Brenda?
Just the one where if it was proposed and moved forward to Bheck, that you could still have the workshops and discuss, and if there was something bigger or something that needed to be tweaked.
Yeah, that's what we do in the Rules Committee. So let's keep doing it.
Janie, anything to add?
Yeah, the whole prenup thought just completely derailed me.
That was not my intent.
Sorry.
Uh,
I just, and I've said it all along, you know, there's some things that I think still just have to be looked at. And I mean, I hope everybody really, especially anybody who knows me, knows my involvement in entrepreneurship and, you know, even on a national level. And that's where my heart is. But there's, I just think there are a lot of things that need to be looked at here, and don't want to rush it. Just
would this kind of would this address your concerns, where we would leave it open that the rules committee can still tweak?
well, and so my question is, are we only allowed to look at these 4 rules that are being presented, or if we find that there are, you know, 18 other rules that need to be, you know, that somehow are intertwined in this, can we add those, or is that kind of a later on we'll have to adopt those? Daryl, I got yes and no coming from your head.
Yeah, you are not limited to what you can look at on the rules committee. Just because you send this up to the council does not limit what you want to look at. If you wanted to, if you decided, hey, we found 15 other rules that we want to make changes to, along with these 4 or 5 changes, when it comes back after public comment, you can say, hold up, reset, we're going to send it all up as a package. Or, I mean, you're not binding yourself. You're not stuck. You have plenty of flexibility to make any changes you want to make later on. So don't worry about that. You're not committing yourself to something you can't get out of.
Thank you, Daryl. Any further comment? Okay. Hearing none, is there any motion before the board?
Steve, are you calling for a motion to approve all 4 of these or just one?
It's gonna, you have to stipulate it in the motion.
Well, I mean, we haven't, I mean, have we discussed these rules one by one here? Because I mean, there's some stuff in there that like the supervision hours and things like that need to be discussed.
The 4 to 6?
Yeah.
Bring it up.
Okay. Christina, can you put the rules up for us, please, so we can kind of go through this and. Okay, Christina or Daryl, if one of y'all will take us through each and every proposal one by one, please.
All right, so the first one that you guys have is for 681.2 for definitions related to independent, or definition for independent practice. The practice of providing professional counseling services to a client without the supervision of an LPCS. So that was one of the things you guys had discussed previously, was identifying a definition for independent practice.
Okay.
But we are specifically saying you cannot do that.
It relates back to the change that's going to come up in the next rule, Christina, if you'll scroll down to D, and that's where it specifically says independent, you cannot engage in independent practice. So I believe a previous discussion was maybe we should define that to make it clearer, and then that's where the prohibition is in subsection D right there.
Correct.
Okay, next.
Next one is still in 681.91 J. And it looks like we were crossing out the previous language of an LPC associate does not own client records. They are the property of the agency, organization, or the LPCS. And the new proposed language would say The possession, access, retention, control, maintenance, and destruction of the client record is the responsibility of the person or entity that employs or contracts with the LPC associate, or in those cases where the LPC associate is self-employed, the responsibility of the LPC associate. The next one would be removing L, which said an LPC associate must not accept direct payment for services from a client. It looks like for N, I don't have it highlighted here. Let's see, the new language, the LPC associate must not, or existing plus adding in here, LPC associate must not represent himself or herself as an independent practitioner. The LPC associate's name must be followed by a statement such as supervised by the name of the supervisor, or a statement of similar effect together with the name of the supervisor. This disclosure must appear on all marketing materials, billing documents, and practice-related forms and documents where the LPC associate's name appears, including websites and intake documents. Do you want to discuss those proposed changes just on 68191, or would you like me to continue to the rest?
Oh, you can keep going.
Okay. Let's see. First, just for 681.92, related to the experience requirements, this is the one where we've had a lot of feedback from changing the minimum of 4 hours to 6 hours of supervision per month.
Yeah, I'd like to set the record straight on this. Patrick put this in here, throwing you under the bus hard, Patrick. This was never, I don't think, ever really a serious consideration. We were just looking at what other modalities were, what other licenses and other states were using. As far as how many hours of supervision a person received when they ended their associateship or internship, right? And so it seemed that one of the arguments, correct me if I'm wrong here, Patrick, was that like, for example, LMFT associates will probably most likely have more supervision than an LPC associate at the end of their associateship as it stands now. Is that
Right, under the LMFT rules, associates are required to have 200 hours. I'm not necessarily recommending making this change. It was just a suggestion based on feedback from the committee that if you are looking to increase that and you were to take 6 hours per month, multiply it by the 18, you would get the 108 hours, I believe, if the math is correct, which would get you closer to what some of the other professions have, which is somewhere between 3,000 supervised hours with 100, closer to 100 direct hours. So
yes,
Patrick, we could also get there if we did 4 hours a month for 24 months. So if we extended it to 24 months like the other boards, right? Same math.
The math would work out because that would be similar to LPAs have to do 1 hour a week for 24 months, and that would be I think the math is like 96 hours, but it's closer to 100. I'd have to go back and do the math. Daryl promised there wouldn't be any math today, so. But I think it's closer to that 103,000 if you do change it to the 24.
Yep. So this is a topic that I think would be best addressed by our fancy new committee on standardization, rather than making a change like this now, which is going to impact 100% of LPC associates, whereas the change to operate your own business will probably maybe impact like 10% of them, maybe more. I'm not sure, but based off of what the LPC Association of Texas shared with us, it does not seem that 100% of associates want to go out and start their own business tomorrow. So a change like this to me seems to be unfair, and really I just kind of like to take this out of the conversation if there's no opposition to that.
I don't think you're going to have any opposition. I think that we should take that out and leave it at 4.
Point me, yay.
All right, so the next one would be related to 681.93 under the supervision requirements, where we were adding that G. It says a record of acknowledgement that the supervisee is self-employed if applicable. And that would be what would go in the supervisor record.
Yeah, and that would be, this will be on the application as well, right? Or the supervisor, the said form as well.
We could probably add some language like that on the agreement form. Is that what you're asking?
Yeah, because
Yeah.
we discussed in the rules committee meeting about having a specific, and it could just be a box. It can be a one statement box that just says, I acknowledge that this associate intends to, or is, or will open their own business and work, and intends to work out of that practice. That way a supervisor is fully acknowledging that, and that they're fully aware of it, and we don't find ourselves in some complaints meeting and someone's like, well, I didn't even know they were doing it.
Okay. And then let's see, for B as in boy, so the language here that we struck was, well, it's kind of in between. So I'm gonna just read the new proposed language. Both the LPC associate and the supervising LPCS are fully responsible for the professional counseling activities of the LPC associate. The LPCS may be subject to disciplinary action for violations that relate only to the professional practice of counseling committed by the LPC associate, which the LPCS knew about or due to the oversight nature of the supervisory relationship should have known about. And I think that was it. Yep.
All right, thank you so much. Sometimes Patrick likes to put stuff in rules that I have to find, keeping me on my toes, Patrick. Thank you. All right, Mr. Chair, I feel good about that.
Thank you, Dr. Taylor. I'm glad we did that. Let's all be very clear on what we're going to vote on.
I would like to make a motion if we're.
Christina, can we go back to full screen?
Yes.
Okay, Dr. Taylor, you're going to make a motion?
Yes, I would like to find my agenda. Start there. I've lost my agenda. All right, I'd like to make a motion that we accept the proposed rules changes listed in the document that we just reviewed, minus the change in supervision hours. And I'm sorry, I lost my agenda, so I don't have the here it is. Longest proposal ever. Here we go.
Did you want to include the suggestion that Patrick had made that we also stipulate that rules was going to take another look at this, even though that we were going to accept them?
I thought we were going to do. I mean, we're still going to look at them, right? But we're accepting this and moving forward with this and pushing this to Bheck. Yeah,
that's what the motion is.
Yeah. So I propose that we accept the proposed changes to 681.2, 681.91, 681.93, but not 681.92, which I believe was the 4 to 6. Yeah.
Correct.
So I, double I, and IV, 1, 2, and 4.
Okay. There is a motion. Is there a second?
I second.
Okay. Dr. Muna seconds the motion. Ms. Hall, we're going to need you to take yourself off of mute before we vote. Everybody that's on camera, you can either say aye or you can raise your hand. So everyone in favor of adopting the proposed changes to 681.2, 681.91, 681.93, please say aye or raise your hand.
Aye.
This is Vanessa, aye.
Loretta.
Okay. All opposed? Nay.
Nay.
Thank you, Ms. Stubblefield. The proposed changes passes 8-1. Okay, everybody, do we want to take a quick break before we finish up the rest of the agenda? Or we want to keep going? Quick break? So let's take 5 minutes and then we will finish up the rest of the agenda. See you back here in a minute. Through this, as it's Friday afternoon and I know we've already put a lot of time in this, so let's get going. Item number 13 is a Bheck update. Dr. Taylor and I, my Bheck buddy, we joined the meeting this past Tuesday. As we previously discussed, council voted unanimously to move to using video recording minutes instead of written ones. That's a change that everybody seems to be very enthusiastic about. As we've also mentioned, council voted to create an ad hoc committee in order to identify where we can standardize rules and procedures across the member boards. Dr. Taylor volunteered to join this committee, and I know that he already has a full plate, and I commend him for being willing to add something else to it. So thank you. And again, funnel your comments through Christina, and they'll get them over to Dr. Taylor.
Thank you.
Council undertook a few administrative level changes. We included one of them of note, included to vote to reduce late fees for tardy license renewals. The thinking behind this is we want to kind of balance out. Late fees are really to encourage people to timely submit their license renewal, and as opposed to a punishment for not renewing it. Daryl, am I kind of viewing that the correct way? We want the late fees to encourage on-time renewals, but there was just there was a bit of parade of horribles about late fees that had really accumulated, and it was becoming more punitive than it was losing that punitive aspect to it, as opposed to being encouraging for the timely renewals. So that's one thing that Bheck undertook. Bheck can make those kind of changes at the administrative level, and that's one that we did on Tuesday. Finally, council reviewed 8 rulemaking proposals that came from our board. They voted to accept the proposals. The proposed changes will now be submitted for publication in the Texas Register. And comments can still be filed on those proposed rules. Dr. Taylor, anything to add for Bheck?
Just that we need to get t-shirts that say Bheck buddies. That's fun. No, I thought it was a wonderful meeting. It continues to be an honor and a pleasure to serve with our fellow boards. It truly is a very open and respectful environment, between our boards and the other boards, and it's been a wonderful experience for us to get together and really try to solve, I think large problems together as one agency, as a mental health care agency, which I think is really amazing.
Yeah, I think the way to think of it is, if Bheck was this giant machine, then we've got the machine installed. Now we're starting to turn it on and see what it can do. Yeah. And we're finding areas of efficiency. Everyone's got the same goal in mind. Let's make things quicker. Let's make things more responsive. Let's eliminate confusion and ambiguity. And that's what we're working on now.
Yeah, and things are working. And I know it's frustrating with phones, and it's frustrating with delays, and those things are difficult. But the efficiencies that we have started to develop at that agency level has been amazing. So thank you very much to staff and to everybody that works so hard to get these things done.
Yep. Okay, item 14, the board chair report. Number 1. We're excited to have Dr. Muna join us. It's great to have a new professional member here. I told you, I look forward to meeting you in person. Thank you for just jumping. We kind of threw you in the deep end today, and appreciate your comments and your insight. You're gonna fit in well here. We're excited to have you. I'm also happy to report that Dr. Taylor, Dr. Bradley, and Ms. Campanone have all been reappointed to the board. Very, very excited to see those names get reapproved. Finally, I don't know if she's on here, but she probably is because she's awesome. But thank you to Dr. Jody Elder for her contributions on our board during her time here. We wish her well over at LMFT. And frankly, I think we're going to cross paths with her because I get the feeling that she'll be up on Bheck someday soon. I kind of see that coming. So we'll cross paths with Dr. Elder here pretty soon, and we're grateful for the time that she was here. She has a unique perspective, being like a dual licensed. That was very valuable.
Mm-hmm. Sadly, I don't see her in the attendees list, but she can watch it on YouTube now.
That's true. Okay, I'd like to recognize staff for your work. The building was flooded back during the February freeze. For those of you that didn't know this, the state office building that houses licensing department had a pipe burst and it flooded the floor. Staff quickly pivoted. We got licensing renewal work back on track. This is very well done, especially considering all the challenges associated with COVID. And if this is the first that you're hearing about this happening, that tells you how good of a job they did responding to it. Because I saw videos of Daryl up to like walking in ankle deep water, and I was like, this was not in the brochure about joining the board. But the fact that you may not have even heard that this happened tells you how good of a job staff did with quickly adjusting to the change. And if there was a final nail in the coffin of the building, then this apparently was it. Daryl, any updates on that? It seems like we're up and moving.
Yeah, no, this is where I was talking about before we came back in, formally called the meeting back to order. The licensing division had been housed over in what we call Tower 2 of the hobby building. My office and the administrative division and what used to be the enforcement division is over here in Tower 3, two totally separate, almost separate buildings, really. Tower 2, where licensing was, the pipe that burst right above our licensing division, starting with the receptionist desk, flooded it, destroyed it, just washed right back. It ran right down the aisle amongst all our licensing cubicles, wiped all of them out. So we had to, and fortunately though, we had been doing our scanning, we had digitized everything. So everything that was destroyed was bound for the shredder anyway. There might've been a few apps, but for the most part, everything we had done ahead of time to get everything digitized paid off. It saved our rears there. We have now moved the entire licensing division over here into Tower 3. We've kicked enforcement out. They are now working entirely remotely. Not ideal, but it's what we have to work with. TFC is not going to rebuild the office space over there because it's a $2 to $3 million price tag to rebuild everything that was destroyed. And this building's slated to be torn down, or it will be. I don't know who would buy it and keep it. It will be torn down, so nobody wants to spend that money. Which means we're going to all have to snuggle up and stay cozy for at least another year till we can get into the Bush building. The unfortunate side effect of that is you lost your board meeting room. We had a dedicated board meeting room over here. You've lost that. I had to convert that into office space for staff. So if we decide to come back in person and do hybrid meetings or full in-person meetings, I'll have to find a place here in the hobby building. Now, I'll be candid with you all. The internet in this building is absolutely horrible. The Wi-Fi is. The bandwidth is not, it will not power this meeting that we have here. The stuff I had over at Site Board wouldn't power this meeting you're doing here today. Bheck really ramped it up, but we don't have that. We don't have Bheck's capabilities when we get outside of our physical office space into these shared conference rooms. So I'm not, if we go back to in-person meetings, it will probably just be straight in-person meetings. We might not be able to broadcast if we stay in the hobby building. Once we get to the Bush building, I'll have you set up much better. There we will have full capability to do in-person hybrid style meetings where every one of you could be here. We could broadcast it, or some of you could be here and not, and just zoom in. So it'll be a whole different ball game once we get over there. But and I missed I missed the opening ceremony of that today to be here with y'all. So I'm missing barbecue to be here with the LPC board today. So, but you're worth it. That's my update.
Okay, a couple more items from me. Jan Freese, our board liaison with TCA, has done an excellent job keeping me apprised on the status of key legislation over at the Capitol. We still have a ways to go, but hopefully we're going to get some good things out of this legislative session. You're going to hear a little bit more about that in a second. Jan, I'm sure you're on here. Please know that I'm grateful for your efforts and TCA's efforts on behalf of the profession. I mentioned earlier in the Bheck update, our proposed rule change were accepted by Bheck on Tuesday. However, we've received some comments regarding the proposed change in definition for art therapy. I'm going to recommend that these concerns be addressed by Rules Committee and the full board at our next meeting. And again, comments can still be filed on the proposed rules following publication in the Texas Register. My last item is, if we wanted to meet in person in September, but we didn't have a building in Austin to do so, that the board has met at different locations in the past, and maybe that's a possibility for one of our fall meetings if we wanted to try to get together in person. We have met, when I first joined the board, our first 2 meetings were at Dallas Theological Seminary. So is that a possibility?
Like specifically at DTS or just at any university?
DTS or
I'm sure the universities would love that.
If we only had a board member who worked for a university and might want to host the board for, I know, just putting that out there.
I don't have a problem with that. We just got to logistically talk to our events manager. And if that's a true proposal, I can definitely get to work on that. And it'll save some commute time.
I was more sort of a trial ballooning that, because we have met, like I said, we've met at DTS before. That was my first 2 meetings on the board. But trust me, I do not want to burden staff, but if they were open to it and we considered getting together in person to be safe and something that we wanted to do, then maybe we should, think a little creatively and see if we could come up with something. Okay. We'll just leave it at that. That's all I have for the board chair report. We'll move on to item 15, the board administrator report. Christina?
All right, so just a quick update as I give you guys each time. We have 3 staff members still on LPC, continuing to rotate days for answering phone calls and return phone calls. The other time they're spending the time processing applications. Deficiencies are being sent by email. I'm going to read off the dates here in a few minutes about the timeframes that the staff are working on. If your date, if you applied prior to that date, you may have a deficiency. So go back and check your emails. If you didn't provide us an email with your initial application, we will be sending it by mail. Let's see. Oh, those deficiencies have direct email links to send your response to, as a staff are trying to expedite it and get that response directly to the right person to continue with processing. Staff are continuing to receive a high volume of phone calls and emails, doing the best they can to stay on top of that as they continue to process applications. Supervisors still have the ability to go online and add the experience hours. We are continuing to work on another project. Ms. Nowak here with Bheck has been working really hard day in, day out on trying to update our processes. What we're hoping sometime in August at latest, we're thinking, it's not 100% sure right now, but the hope is that we have the complete upgrade process online. So currently they can go in, these supervisors can go in and add the hours, but the form is still required to be submitted. So what Ms. Nowak is working on is trying to avoid the paper trail of the form and have it all electronic online. So that should save some processing time and paperwork still coming in. Staff are currently working for new applications and for out-of-state applications. They are on April 4th. And for upgrade applications and supervisor applications, they are working April 19th. So continuing to, work as quickly as they can while ensuring, of course, that the requirements are met. Right now, we have the renewals that are being worked on for April. So, they're continuing to work as quickly as they can. I think we have one person who's doing renewals. And I think they're looking to get someone else right now, but I'm not, is that true? Okay, I see Daryl nodding. So it looks like they're trying to have another person to also work.
We're looking to hire another individual that will be part-time on renewals and part-time on the MFT program.
Awesome. Other than that, for the licensing end, that kind of wraps that up. Again, staff are working as quickly as they can. Our two new people, definitely learning as they go, but have really just, kicked it up a notch, and they're getting through everything, and the processes that they have are starting to really work and get going. For enforcement, we have the update on the compliance report. We have 18 cases that are continuing to be monitored. We still have that one case out of 18 that it's back with legal to process in the next appropriate steps for that case. So, legal they have all different avenues of steps that they do. But everyone here, I can tell you guys with what we had at HHSC compared to what we have now here at Bheck, just having the resources and staff and everyone working to get to that goal has really helped. And I hope you all can see that just in every avenue, licensing, enforcement, investigation, it's really, coming along and continuing to get better. And I see it will continue to get better. That's what I have.
I will add that the modules we're working on for the supervisor, I am really, I'm ready for that to happen, to get away from relying on the paper. That will allow real-time access by the supervisors to enter hours, to drop supervisees. Supervisees will still have the ability to submit a form if they fire their supervisor or, don't want to be supervised by an individual, they can submit a form. The modules are only accessible by the supervisor or not the supervisee, but this should reduce the amount of paperwork that we have to deal with here in the office, and it ought to make life a little bit easier for the supervisors as well. So we are really pushing hard to make this happen quick and then spread it amongst, y'all are kind of the guinea pig, and then we're going to carry it out, duplicate it on the other licensing programs. So.
You're on mute.
Sorry. Other than that, I just want to thank the board because I know I send you guys a lot of material and it kind of gets updated throughout up into the morning of the meeting. So just thank you for, staying on top of that and coming to the meetings prepared and being available. Absolutely.
Thank you, Christina. Item 16 is our operations manager report, and I assume that's going to be Mr. Spear.
Correct.
Yes, indeed. Everything that I would cover is pretty much already covered by Christina or by Daryl. I do just want to point out that some evidence to the improvements that are occurring under Bheck can be found in the number of legislative inquiries that we get. In October, we received over 100 legislative inquiries. And in April, we received, I believe it was 6. So that decrease in the number of legislative inquiries we're getting speaks directly to the operation getting up and running and starting to hit its stride. And that's it for my report.
All right, thank you, Tim. Legislative update, that's going to be Daryl.
Okay, I will freely admit I am not prepared other than I'm going to have to go off of memory here.
Daryl, I think you've done great so far. So I'm not worried about it, buddy.
I'm going to wing it here.
Did
House
they
Bill
vote 3626 yesterday?
Yeah, it's out of the House.
Okay.
It passed the House yesterday. House Bill 3626. I'll send you all a link to it so that you can look at it. It's probably going to be the most significant bill that impacts the agency coming out of this legislature, other than the budget. In short, what House Bill 3626 does is it makes clear that an individual, or it gives the board the authority to, I don't want to say grandfather in, but if somebody is licensed in another jurisdiction and they have been actively practicing in that jurisdiction for 2 years, they can then come into this state and get licensure without having to reprove up all their supervised experience. Because in some jurisdictions, they don't meet the 3,000 hour requirement here, yet there's really no evidence or data to support not letting that person get licensed here. They're not a risk to the public. They haven't been a risk or a problem in their home state, so why are we worried about it here? But that 3,000 hour, I mean, you guys are more familiar with it than anybody else. That has caused a major problem for y'all and your folks in the past. This bill is going to create a bridge across that problem for you. So I'm crossing my fingers. I'm hopeful, that it goes the distance. I know Jan and TCA and Texas Association of Marriage and Family Therapists, it also affects marriage and family therapy. Those two associations are working hard on that bill, supporting it. So it's cleared the House. It actually includes both marriage and family therapies, counseling, and then social workers were added back into it yesterday on the floor, a House amendment. The only board it doesn't cover is psychology. Psychology already has a measure that basically does this, except theirs is 5 years instead of the 2. So I think it's going to really help. As far as other bills, the budget, we're in conference committee right now, which means the House passed one version of the budget that didn't match what the version of the budget passed by the Senate. So each one selects conferees, and then they come together and figure out what the ultimate budget should look like and take it back to their respective chambers, which will approve it. And then we're off and running. I'm hoping that the Senate version of the budget comes through, because in the Senate version, they granted all of our exceptional item requests. In other words, we requested 4 additional FTEs, the money for those. We requested money to bring our accountant from a part-time status to full-time, which for a reason that doesn't really impact the board, but it's the comptroller making us use what we call CAPS Financial, which is a much more complicated accounting system. So we need somebody full-time to do that. And then they covered our moving costs over to the Bush building. So those are big things. The Senate side covered all of that. The House side covered most of it too, I think. I think the only issue or discrepancy was the FTEs, the 4 FTEs. So hopefully we'll end up with what the Senate side is. As for other bills, I can't remember any other bills that directly impact this board or the agency overall. There were a lot of bills filed that spoke to banning conversion therapy. I forget some of the other names that practice is known as, but there were a lot of bills that spoke to that. Those bills haven't moved anywhere as far as I could tell. And we are coming up on you could call it the final hours of being able to do, I think it's next week is going to be a deadline where if a bill hadn't made it out of committee, it's not going to make it out of committee. So we're really coming up in the wee hours of the legislature where things have to start moving. They've got to get out. They've got to get out of the House so that they can get over to the Senate and go through the process in the Senate side. So we're down to the finish line here, ladies and gentlemen. So that list that I've provided y'all in the past, if it says introduced by the bill and it doesn't say anything else, you can forget that bill. It's not going anywhere after next week. So other than that, that's all I have to report, Mr. Chair.
Thank you, Daryl. We'll now move on to item 18, public comment. Christina, will you coordinate, please?
Absolutely. So anyone who's interested in public comment, please raise your hand in the Zoom functions. And for the board members, you all did receive 19 written comments yesterday, and then an additional 2 that were emailed this morning. So you have those to reference, and let's see if we have.
Patrick, will you keep time and give a 30-second warning, please? Thank you.
Okay. The first person I have is Miss Sandra Martin. Miss Martin, you are muted. There you go.
Unmuted. Good Good
All right.
afternoon. You've given us a long afternoon, morning and afternoon. We're glad that there's going to be continuing work on those proposed rules. There's a lot of things to be looked at and considered and researched. And so I'm glad the work goes on and there's lots of time. And as board member Janie Stubblefield said, let's don't rush it. As also with prenups, let's don't rush it. I do want to appreciate that there is a colleague that's keeping our board chairman informed of legislative action. However, I'm quite certain that in some of those bills, not including 3626, our perspective on that legislation would be very different from hers. So we'll be sure and keep you up to date on what our perspective is on that legislation. I am grateful that this.
Ms. Martin, feel free to email me directly.
Thank you, I will. Also want to invite you to our conference. We're recovering from the great freeze that killed the last conference. We've resurrected it. It's going to happen August 12th to 14th. And one of the things we're going to be considering was brought to light by, by this interaction regarding those bill proposals, was that obviously some way there's some brokenness in our supervision department going on with supervisors in the state of Texas. I was not aware of it. I had a wonderful internship, but apparently there is some brokenness among us. And so we're giving some real time, August 12th to 14th, to kind of bringing those issues to the table and doing some reconciliation. That after all is what we're called to, is reconciliation. So we're going to try and dig out what's going on there and why, and do some things maybe to repair the damage. So thank you for your hard work for us. We do appreciate it so much. And thank you. It's an enjoyable afternoon, though a long one. I need some lunch. Thank you.
I'm with you. Hey, Sandra, where's the conference?
It's in San Marcos, Embassy Suites. If you ride a bicycle, bring your bicycle, because you can ride the hills on the university campus there and get all your exercise for the next season.
Cool.
Thank you, Ms. Martin.
You're welcome. Thank you.
Okay, let's see. Next person I have is Jan Fries.
Mute. Okay, thank you very much. First of all, I want to express my appreciation to the entire board for all of the hard work that you do. I want to especially thank Stephen for the shout out. I have one technical correction. I hate to contradict Daryl, but sometimes, well, I guess I shouldn't say I hate to contradict Daryl. Sometimes I like to challenge
Love
him.
it, Jan.
House Bill 3626 is not actually fully out of the House yet. It has passed from at 12:30 this morning. It passed on second reading to engrossment. Still has to pass on third reading. We're expecting, that's pretty pro forma. We're expecting that to happen and then to go over to the Senate. We are already reaching out to our allies in the Senate to see if we can move that pretty quickly through the process. It's a fairly uncontroversial bill. I would add a couple of points on it that I think would be of import to you. One is that one of the changes in the bills would set the 300 hours of practicum as a floor and not a cap. So currently the law says that the practicum has to be 300 hours. The bill would change that to at least 300 hours. So that gives you a little bit of flexibility there, should you decide to modify that at all. It also in statute asserts the title of LPC Associate, changes temporary license to LPC Associate. So those are a couple of other changes in there that we think are really, really important. We're very excited and confident that you guys are going to get the money in the exceptional items. The conferees from the House side are very much friendly to us, and we've been advised that the chair is that Bheck funding is his highest priority on the House side, so that should make that be pretty smooth sailing. And of course, with the announcement that there's an additional $3.1 billion available in the funds, TCA and NESW Texas are now asking them to consider a rider that we had proposed, giving the board an additional $250,000 over the next 2 years, with LPCs and social workers agreeing to a short 2-year cycle only increase of $5 in fees. to fund that. So we're pushing on that as well. I really, really want to thank you for the action that you took today on your rules. So most especially, I want to give a shout out to Dr. Taylor. Thank you for pulling down that that change in the hour rules. You're going to make my weekend so much better, as I don't get a gazillion calls on that. Yours as well, I'm sure. I also want to I want to thank you for submitting a proposal, which you know is accepted to present at our Professional Growth Conference first week of November in beautiful Galveston. So I hope most of you will come and attend. And then the very last thing that I would say is, I know that it is not within your purview, but we are still very concerned that the late fees on renewals are still can really have a difficult impact on LPCs. LPCs are one of the lowest paid behavioral health professionals in the state. And the fee that you have to pay if you're late by a day far exceeds what you'd have to pay to American Express or MasterCard. So I would say, please push on that, push Daryl to start the task force. I see your fingers, Patrick, and I'm
3 minutes, yeah.
but thank you.
Hey, Jan, while I've got you, will you send me the House conferees, please?
Yes, happy to.
All right, thank you.
And Jan, that is happening, the late fees. We're going to work pretty hard to get rid of those.
That would be really helpful too. So many people, so many people.
Yeah, we talked about it in Tuesday's Bheck meeting.
Thank you, Jan.
Thank you.
Okay, next person we have is Mario De La Garza.
Hello, everyone. Mario De La Garza. I'm the liaison to the board for Texas Association for Counselor Education and Supervision. Thank you so much for all your work today. I know it's been a long meeting. Just had a few things to talk about. First of all, I just want to thank the board and your work in making these the public or the meeting minutes public and then putting that on YouTube and that work. I think that's going to be really helpful. One of the things that Tasis discussed was how was this going to continue in terms of being transparent and were people going to have access to this? So I appreciate the conversations and moving that into the YouTube area and having that. And also I appreciate the conversations, or we appreciate the conversation about what are we going to do in order to make sure that people can still attend the meetings if they're not virtual anymore. So we appreciate that. I also wanted to say that I appreciate just all of the conversation about protection of the public, especially in terms of the rule changes that were proposed and that are being discussed. And the additional stipulations that were added to those rule changes based upon the Rules Committee meeting and the public comments that were proposed to that. One thing that I would want to remind board members about is that one of the things that you see or people think is that all individuals that get licensed as LPC associates come in with the same educational requirements. And depending on whether they are from a K-CREP school or a non-K-CREP school, you have some people that don't come in with as much experience. So I think that's just one consideration to keep in mind there. Another aspect of that too is, although the public really, and a lot of conversation was about trusting the supervisor here, how much did the public really understand an LPC associate versus a fully licensed LPC, and what that alphabet soup really means? Because a lot of times public members don't really know that as much as we do that live in this life of LPCA, LPCS, LMFT. And so in protecting the public, in protecting the public, I think it's important to realize that they don't know that. And one final thing I would just ask, I know that there's going to be those modules for supervisors, which we appreciate in putting all of that online. But if there could be more direction and guidance, and I think there are some directions and guidance in terms of using those modules for the supervisors, not all of us are as technically savvy as we'd like to be sometimes. So thank you so much for your work. We appreciate you.
Thank you, Mario.
Thank you, Mario. Okay, and it looks like the last person we have is Tom Kennedy.
Yes, I want to say thank you to all of you. It's been a long day, and like many of you, since we're now at home, I would like to get up and leave the house when this is over. But I am the ethics chair of the Christian Counselors of Texas, work with Sandra. And I especially want to take this time to thank Daryl and his team, bunch of superhumans who have done just a phenomenal job of reducing the applications and the backlogs. I was at the Bheck meeting, Daryl, and had to leave early and didn't get to give you the comment then, but I want to thank you and your team for all of the really extra hours y'all put in to make this look, make us look a lot more professional. And so thank you very much. I do want to make one comment. I agree earlier, living in Houston, this has been great that I can attend the LPC board meeting without having to travel up on a Thursday, rent a hotel, and come in and spend the day and then travel home. I would hope that in some way we can continue the virtual meetings with the ability to comment at the end of the session as well. So that's my 2 bits on that. This has been really great in that I can give comments, but I also can attend and be a part of this session. So thank you very much, and I'm through.
Thank you, Mr. Kennedy.
Thanks, Tom. We have to do the same thing. And as Steve learned the hard way, reimbursement's not easy. How dare you get that upgrade, Steve? How dare you?
I'm still trying to figure it out.
That rented Toyota Corolla. How dare you get that upgrade?
For those of you who don't know, I was just going to say, Dr. Taylor sat me down one day and said, Steve, did you join the board because of the travel reimbursement benefits? I said, no. And he said, exactly. Let it go. and my attitude was completely changed that day.
Yeah. Yeah, I got to tell you, they made it so difficult for us now. I've just stopped submitting reimbursements. I don't even I'm like, whatever.
Wait, you haven't had to do it yet with Bheck, have you? That was with HHSC, right?
Oh, was that with HHSC? No, I thought it was like right when we moved to whatever.
Oh, was it? Maybe so. I have one person that was a phone call, so I need to just double check and see. I'm sorry, guys. Sorry, that was my fault.
No,
let me just see if they.
We're the problem here. Go ahead.
It's okay. It's okay. Sorry to cut you off.
Put on the agenda that like break session about reimbursements though, because that should be on every agenda item.
So caller ending in 6195, if you are interested in providing public comment, please unmute yourself, which is *6. Okay. Oh. Would you like to provide public comment? Okay. All right. So it looks like we have completed public comment.
Thank you, Christina. Item 19, items for consideration for future committee and board meeting agendas. We do have some that we've identified from earlier in the meeting, but does anybody have anything that they would like to add? Okay, hearing none. Our last item, announcements and comments not requiring board action. I would reiterate, as Sandra Martin told us, Christian Counselors Conference, August 12th through the 14th in San Marcos. Our next board meeting is September 10th. Is that correct, Christina? The 10th?
Correct. I think it's actually the 11th. Yes, September 11th. I think, I'm gonna have to double check. I think we changed it to the 11th.
Okay, our next meeting, September 11th. That's all I had. Any other announcements or conferences or?
National Board Conference is coming.
Yes, September 11th is a Saturday.
Okay, then it is the 10th.
Okay.
Sorry, I've been lying to everybody.
we show the 10th on the website.
Yeah.
Okay, good.
September 10th.
Yep, National
Thank
Board
you.
Conference is coming up, which is going to be exciting in Denver. And
So
then
that's, yeah.
yeah, and then I don't know, Daryl, what the how we do it now, what the protocol is, but I would be happy to go to the CCA conference and talk or answer questions or whatever they need.
Is this an organization that we're a member of?
Well, it's Sandra Martin, so I'm assuming they're
Oh, okay.
like TCA. So
Oh, I got you.
I'm happy.
I thought
to do that.
Okay.
I don't know.
I guess it depends on if they invite us.
She just invited us.
Oh, did she? Okay. Okay. Well then, yeah.
Welcome to the meeting, Daryl.
We can send someone.
Yeah, so
Any
it looks like,
other announcements?
so I think TCA is November 3rd through 5th. Ours is September 10th. NBCC is August 4th through 6th. And then Christian Counselors was August, what did we say? August 12th through 14th.
Okay. Anything else to add?
The only thing I'll add, and I hate to leave on a bad note, but I'm watching a case out of the DC District Court, U.S. District Court in Washington, D.C. that deals with counseling. It's y'all's profession, and basically it's an interstate practice case. The details of it I haven't read completely yet, but I'll send you the information that I've got. But it's something we're going to need to watch to see how it goes.
This is a therapist in DC that's practiced in like another state.
Virginia, yeah, I think he's licensed in Virginia, but he's got patients in the district, and the DC won't let him practice over
through
telehealth or at all. So he has filed suit, got the Institute for Justice to file suit, which we've tangled with them before at the psychology board. So it's not something we need to watch it. That's all I can say there. We'll watch it.
Okay. Any other last minute items? Hearing none. Thank you, board, for your efforts today, for your efforts over the past few months. This is not the most ideal circumstances, but man, y'all are really making the most of it. And I thank you for your hard work. I know that everyone here cares, and I appreciate that. I'm glad that we have people that care and want to be involved and want to do what's best for Texas, do what's best for the profession. Thank you for that. Hope to hear from you. Hope to see you again soon. Have a great summer, but I'm sure we're going to be in contact, and I will ask for a motion to adjourn.
I so move.
Okay, Dr. Taylor with the motion. Do we have a second?
I'll second.
Thank you, Dr. Bradley. All in favor of wrapping this one up, please say aye.
Aye.
Hey.
Thanks, everybody. Take care. Be safe. Hope to see you soon.